Good morning, everyone. It's nice to see your faces here in the room and on Zoom. We are starting the third of our 4 meetings for the commission to create a plan to incorporate the probate courts into the judicial branch. And we're going to do just a quick round of introductions this morning as we've started every meeting. And I think we'll start with the folks who are participating on Zoom, and then we'll move to the horseshoe. And I'm just going to call on people as I see the screen in front of me. And Justice Gorman, we'll start with you today, if that's okay with you. Oh, there.
Good morning. My name is Ellen Gorman. I'm an associate justice on the Supreme Judicial Court, and I'm closing in on the end of my 2nd term here. So I've been here 14 years.
Thank you. And Tudor Goldsmith.
Hi, I'm Tudor Goldsmith. I'm an attorney with Jensen, Baird, Gardner, and Henry in Portland. I practice trust and estates, and I'm here on behalf of the Maine State Bar Association.
Thank you. Representative Sheehan.
Good morning, everyone. My name is Erin Sheehan, and I represent House District. Sorry. Can you still hear me?
Yes, we can.
Yeah.
Sorry. I'm Representative Erin Sheehan, and I represent District 12. That's downtown Biddeford in the House.
Thank you. And Register Ayers, it's nice to see you.
Thank you. I'm Kathleen Ayers, and I'm the Register of Probate from Kennebec County. I've been there for 28 years, and I have been president of the Maine Association of Registers of Probate several times. This is my 4th time being the leader of that group. And good morning.
Good morning. And let's see, next, Judge Crockett.
Good morning, Jared Crockett, probate judge in Oxford County, representing the Maine Probate Judges Assembly.
Thank you. And Julie Howard.
Good morning. My name is Julie Howard, and I am the manager of operations for the York County Courts. I've been doing that for 3 years, and prior to that, I was in Portland for the Cumberland County manager of operations.
Thank you. And Catherine Wiltuck.
Good morning. My name is Catherine Wiltuck, and I'm the Director of Court Process Planning and Services.
Thanks. And Leo Delicata, would you like to start us off in the room?
Thank you. Good morning. My name is Leo Delicata, and I'm a lawyer with Legal Services for the Elderly.
Good morning. My name is Libby Mitchell. I'm in my 5th year as the Kennebec County Judge of Probate. I am selected to be on this commission on behalf of the Family Law Advisory Commission.
Hello, I'm Barbara Cardone. I represent House District 127 in the Maine House. That's part of Bangor, and I am the House Chair of this committee.
Judge Martin.
Good morning. I'm John Martin. I'm a district court judge. I sit in Rockland District Court.
Thank you. And we're joined by our OPLA analysts, Sam Seneth and Janet Stocco. And I'm Ann Carney, and I'm the Senate co-chair of this commission. And so we have a full agenda today. We finished the first step, introductions. Now we're going to move on to a review of the proposed model and outstanding issues. And I think what I'd like to do before we kind of dive into the model, just to orient people so that everybody knows what lies ahead, I'm just going to go over quickly the steps that will happen once the work of this commission is done. We will propose legislation based on the model that we agree on. That's part of our charge. The details and overarching policy of moving the full-time appointed judges, moving the probate judges to full-time appointed judges within the judicial branch will be fully vetted at a Judiciary Committee public hearing on the bill that we recommend as a commission. The Judiciary Committee will discuss and potentially amend that bill based on the information that we've learned during the committee hearing process. And then the Judiciary Committee will vote on the bill and issue a report. It could be an ought to pass report. The bill could be amended through the Judiciary Committee process and come out ought to pass as amended, could receive an ought not to pass report, or a report that's kind of a combination of those things. Once the Judiciary Committee completes its work on the report, the Office of Fiscal and Program Review will prepare a fiscal note that sets out the fiscal impact of the legislation. And if there's more than one ought to pass as amended report, they could do multiple fiscal notes. And then the bill, once the bill and the fiscal note are ready, they will be presented to the House and Senate for a vote sometime before we adjourn in April 2022. So that is just a very quick thumbnail sketch of what lies ahead once we complete our work as a commission. And before we move on, are there any questions about what that about the process? I know we have different levels of familiarity with the legislative process. I am not seeing any questions. That's great. Okay, well, as questions come up, please feel free to raise them. And so at this point, we are going to move on to reviewing the proposed model and outstanding issues. Let's see. I think commission members, it probably makes sense for us to have Janet or Sam screen share. Does that sound good to everybody? So we're all looking at the document together. People, does that sound like a good idea? It does? Okay, I'm hearing some yeses. Great. Thank you. Okay, so what we'll be looking at is the proposed model that we kind of discussed and sort of gelled around at our November 1 meeting. And we're going to take it in chunks. Our OPLA analysts have worked very hard on everything we've done, and particularly this proposed model. What they recorded our conversation and the items we agreed on, and then they went in and highlighted in red text things that we hadn't decided at our November 1 meeting and that we need to continue to discuss and work on. Some of those things we may be able to decide in the context of our conversation today and at our final meeting on November 30. Some things we may decide are better left to resolution by the Judiciary Committee in the course of the public hearing on the bill that is reported out. And of course, we could make one decision and then more information could come forward, and that could be a proposed amendment to the legislation in the Judiciary Committee. And so at this point, I think I would like to focus everyone's attention just on the first paragraph. So there are kind of our three main aspects of the proposed model. One has to do with the probate court, one has to do with the register of probate system, and then the third has to do with reviewing implementation of the commission's work. And so looking at the first paragraph, Representative Cardone, did you want to start with some comments, or would you like me to continue taking us through it? While you're, okay.
I don't have anything immediately to add to this.
Okay, and I see that Judge Crockett has a hand up. Go ahead, Judge Crockett.
I just didn't want to mislead anybody. This is not what I thought the gelling around solution was. I thought when not in November 1st, I believe one of the members had suggested an appointed judge and an appointed register, which to me meant integration into the judicial branch, and I was on board with that. This proposal is sort of a non-starter for me, as I've said to the commission from the beginning. I'll go through and I'll provide what information I can to try to make it as good a product as possible. But it's an appointed judge means it's a state system, and those are county employees, and there produces a number of issues I've talked about before. So I don't want to waste the commission's time with reiterating those. But I'm not in support of it. And when the commission report comes out, I'd like to make, unless all of a sudden we modify this to taking the whole system or appointing the registers with legal background and so forth, as Justice Gorman, I think, had mentioned earlier, then I could get on board with that. I get on board with 8 full-time elected judges. But this proposal, I'm not in favor of. But whatever information the committee wants from me, I'm happy to provide and try to get a good product out.
Thank you, and thanks for sharing your comments. I just want to reiterate to make sure that I have it straight in my mind. So, oops, excuse me. So from your perspective, you would support a proposal, or the reason that you don't support this proposal is because you had envisioned a proposal that wholesale took the probate court system that's currently a county-based system and moved it, all aspects of it, into the state court system. Is that right?
Yes, I believe that from the beginning, I've tried to express the concerns of having a point. I mean, obviously, we've heard these various proposals many times over the last couple of decades from me. I don't support an appointed official over an elected official at the county level. And that creates problems. It also creates problems with the state directing the assets of the county. I think the county commissioners, and they put in some testimony to that effect when I tried to get the information from them on the judge's pay. So yeah, I could be on board with the total integration. I think that's the right thing to do. And I think that's whatever you want for information. Either way the commission goes, I want to provide what I can to help make the best product possible.
Okay, thank you for that clarification. I got it straight in my mind. Does anyone have questions for Judge Crockett on this issue? Go ahead, Leo.
Thank you. I'm just wondering, and we've had this conversation before, but maybe it's a good time to revisit it. I'm just wondering what the legal basis for your belief that there is some impediment, legal impediment, for a state appointed officer to direct or to oversee an elected county official.
I'm not so sure. I've had this conversation before, but I'm not so sure it's an actual legal impediment as it is one of organizational structures, 2 of sound policy, and 3 of general principle. The general principle being elected officials have a certain amount of autonomy and decision making, which is we see that in the legislative branch and the executive branch, where the governor oversees the resources of the state employees. In the county, the only reason the probate judge can really direct the elected registers because the probate judge is elected to that position. In fact, in other states, they use different supervisory systems that are elected in that capacity. So that's, I'm not saying there's a great legal obstruction to the process, except for there could be some labor issues if the probate courts are part of the state system and they're overseen by the state judicial branch. If the scheduling is done by the administrative branch with the judges in different areas, then I think you make a really good argument that the employees of the probate court should be members of the union. I think they'd have a right to do that because, but I'm not a labor expert, but I do recall that being discussed at one point in the past as an issue. But I don't see necessarily a legal obstacle, but I see a management. I see really, and I think when we go through the issues, the outstanding issues chart, I think you're going to see some of those issues sort of rear their head when you delve a little bit deeper into this. But Again, I'm not sure there's a legal block from the outset. I think the resolve said we have to get full-time judges. I think there's three ways of doing it. I support the full-time elected or the total integration of the position. I support a different hybrid than this one. So I hope that helps answer the question.
Well, I'm still a little bit unclear because at different times, it sounds like your chief objection is elected over appointed or appointed over elected, and judicial branch versus the counties. I mean, I look at the district attorney model. District attorneys used to be county officers. They're no longer county officers. They are judicial branch employees and judicial branch officers.
Actually, they're not. If you look under Title 30, I think the district attorney's under 30A. Is that correct? Our analysts might be able to chime in.
No, they're not listed anymore as county officials, whereas the registers still are listed as county officials. And the Attorney General's office has very broad oversight and supervision over what district attorneys do. And in fact, can elect to take any case or any investigation that the district attorneys have. So, that is an example of a county-based legal system that was changed and still works well. The counties still do provide assistance in the form of office space. In fact, it's statutory, office space and personnel. So I'm a little bit unsure of exactly where the non-legal burden lies.
So to
And
your
that,
point,
Judge
Oh, go ahead.
Crockett, let me just, because we have a lot of interest in asking you questions. So if you can, I think what you've told us is that it's more of a structural and a matter of principle, or kind of the policy aspects that you're leaning on rather than a legal objection at this point. Is that right?
Right, but Attorney Delicata mentions an excellent point, is the district attorney system. And he understands why they're elected, because that was how we went from an elected county attorney to elected district attorneys, which I think is an excellent model. If you elected your full-time judges on the district version, that you could do the same thing as you did with the district attorneys. But I don't think you can appoint an individual to do that same piece. And that's why the DAs are elected. So let's acknowledge that as the fundamental piece and how the DA offices came to be, from the conversion from a county attorney to the DA. If we acknowledge that, then I think a lot of the other pieces work themselves out. So that is the model I would support, but that's not this model that's being proposed. What's being proposed is the judicial branch is appointing the judges as oversight of the judges, therefore has oversight of the courts, but all the employees and the assets are county. Under the DA model, the people choose the DA and all the employees remained as in county employees for the respective counties. And yes, they're funded by the state, so the state gets a say. And that is what I think should happen here. So if you're proposing that model, Attorney Delicata, I completely agree. I think that's an easy way around it. Or we take the whole system and we do away with the county courts. Okay. So,
Okay,
I'm
yeah.
sorry, I didn't want to I just want to respond to the comment.
Yeah, thank you. And thank you both for your comments. This is a helpful discussion. Justice Gorman, I think you were next.
Yeah, just to, and I guess this is sort of a broader conversation about what Judge Crockett brought up. What the current proposal looks like is a hybrid proposal. And I think to a certain extent, it reflects the idea that if we opted to suggest a wholesale introduction of the probate system into the state court system, the fiscal note on that would be non-sustainable. It would be a non-starter, and there'd be another commission that looked just like this in 3 years or 5 years or 8 years or whenever the next person got a hold of it. This is messy. I don't disagree with that. And it certainly would be cleaner to have 8 elected judges in charge of the elected officials who then would continue to run the county system. So if we are concerned about the messiness of it, I agree with Judge Crockett, that is an easier way to do it. But there are concerns from the people who created this commission with the notion of elected judges. And so I think one of our tasks is to consider whether we want to continue to have any elected judges in Maine, or whether we want to eliminate not only part-time judges, but elected judges. And if we want to eliminate not only part-time judges, but also elected judges, then the appointment of the judges is where we start. And we either come up with the hybrid system that we're looking at now, which will be messy, or we come up with a system where the entire part of county government that now comprises the probate system come into the state court. And that will be an enormous fiscal note and I think it will take it off the table. But that's just something I think the commission should think about.
Thank you. And I do think let's hear from others, and then I think we should do a deeper dive into that, because one option, of course, could be that we could look at a report that actually sets out a roadmap for a full transition over time that would kind of thread the needle between the enormous fiscal note and the concerns raised by Judge Crockett. But let me turn to Judge Mitchell and then Register Ayers.
Thank you, Madam Chair, and thank you. I have the utmost respect for both Judge Crockett and Judge Gorman, but I came to this commission with what I believe was a charge, not whether I liked doing this, but how to do it and what it would look like. What is the best possible model? And as I studied all the documents and as I've listened to all the intelligent people around the horseshoe and on Zoom, one of the things I understand is that it is okay to have a hybrid model. It is okay to be messy, because I wanted to preserve the very best elements of the probate court. So state appointed judges vetted by a committee, no problem. We can go there. But I do think, at least for now, there is something so unique and so special about the registers that I would not want to destroy that. And I'll tell you why. Perhaps this is even an appropriate comment for a commission. One reason I think the registers are so responsive, they are elected. It takes a certain kind of person who's willing to put the name on the ballot. So when people come into the registrar's office, they get customer service. That is something that the people in our areas, I don't think they want to give up. They walk in there and they get help. They get personal attention, and we're a very form-driven court. So the issue of who supervises and who doesn't, what is now doesn't work, but we could come up with new ways. There could be a chief registrar. There could be other things. The state is always telling registers what to do by all the laws that you pass concerning emergency hearings and everything else. So that's nothing new. So one of the big issues to me today is who pays. So if we can come up with who pays, then I think this hybrid model can work, because we preserve this goal of customer attention coming into that office, that local office. And then the judges, of course, could whether it's 8 or 6, I have no idea. But at the same time, this model meets many of the things that I thought were very important coming into this commission. So though I respect Judge Crockett's opinion, I do like keeping the registers exactly where they are till we come up with a better way to give the service that we now do.
Thank you for your comments. Representative Cardone, I promised Register Ayers that she could go next. Is that okay with you?
Yeah, absolutely.
Okay, I just want to be mindful of the order in which people raise their hands. Go ahead, Register Ayers.
Sure, thank you. I don't want to say too much, but I do want to say that I did have a couple of Zoom meetings this week. One was with the registrars, and one was, I am an ex officio member of the MCCA board, which I forgot to mention, which is the Maine County Commissioners Association. My feeling is no matter what you do, you're going to have opposition from the Maine County Commissioners Association. And I just want you to know that up front. The second, thing is that I asked the registrars to vote on whether they would prefer to be elected totally state or appointed by a governor, appointed by commissioners. I did not get answers. I got different answers, and there's no agreement. A lot of people did not dare to weigh in. Let me just say, but it took me back to why I love to be elected, and I hate politics, and I really don't like running. I totally want to confess that. But the thing is, the difference between the state system and the county system is the commissioners right now cannot fire me. And it's a real bonus in so many ways, because I get to not just go the extra mile, but I get to come to the legislature and I get to tell the truth about what's happening in the system, and nobody can quelch me. And I'm maybe one of a kind who dares to do this most of the time, but I do come before the legislature and the commissioners and tell them where the bear does their business. And it gets me in hot water. But the fact that they can't fire me is good, because you don't want politicians, you don't want, I have wonderful commissioners, and if I were appointed next, if you made it appointed, I'd be appointed next week. I'm not afraid of that. But in some counties, it could be such a political fiasco. Don't tell me that it couldn't be. And I totally think that as much as I would love to be appointed and make my life easy, being elected has made the difference. The clerks of the state system can't come to the legislature and say, this isn't working. This is terrible. They're not allowed to have opinions. I don't want to be that. I want to remain helping people. And so I have to tell you what I want, not what the group wants, but a lot of them feel this way. It's a real tough call. It's a very tough call, because these people run your budgets already. They can reduce your salary. But after the MCCA meeting, I just want to say that I think it would be better if we remained elected.
Thank you very much for sharing that information, and also for reaching out to the registrars and the county commissioners. It's really helpful for us to know. Representative Cardone?
Thank you. I have no doubt, based on past experience, that we are going to be hearing negative things about this bill from the county commissioners, no matter what's in it. I know, and I'm assuming, I know the counties have been opposed to any absorption of the probate court system into the state system in the past, and I'm going to assume that is going to go forward. That objection is going to go forward. However, I do think that there are some points that are more valid about their objections than others. And the one that concerns me most is the one that Judge Crockett brought up earlier about state judges authorizing the expenditure of county funds. And we're going to get into this a little bit later today, so I don't want to go into the details of this, but that is one of the reasons that I am advocating that as part of this first bill, the attorney fees, guardian ad litem fees, and visitor fees, any fees that would be paid out at the case level by a court become state funding and not county funding, so that anything an individual judge is doing in a case at the case level, we have eliminated that issue of spending county funds. It gets, I think it gets a little bit more complicated when you come to the court level of who's paying for what. And I know we have more to work out there. But I think we should keep Judge Crockett's concern in mind at that level, because I do think that is a very valid concern that the county commissioners are going to raise. I do think it would make sense that we have, instead of having 8 individual judges dealing with these issues at a court level, that our proposal include having a chief judge who is going to deal with the counties at this court level. So that's all I'll say for that now. But those were my thoughts on the, we've got this state county funding interface that we've got to deal with.
Thank you, Representative Cardone. Is there anybody else who would like to share their reaction to the topic that Judge Crockett launched us into this morning? And I appreciate it. You reminded me of like the provocative question at the Thanksgiving table. This is a good way to start our discussion. Other thoughts and reactions? Okay, I am not seeing any new hands up. I would just like to share my my thoughts on this as well. I think that when I listen to your concerns, Judge Crockett, I do see that there is a lot of there would be a lot of benefit. It would certainly be simpler to move the entire system into the state court system. I agree with Judge Mitchell that that's a problem for 2 reasons, but you know, the not preserving what's so amazing about the way the register system works, and then also the fiscal note is just going to be enormous. But does it help at all, Judge Crockett, to consider including in our report a implementation that would take place over a significant period of time that would ultimately achieve the end goal that you're envisioning? Or are you likely a no, regardless of whether we take that step of planning and implementation out into the future that could have a fiscal note that was sustainable?
I like the collaborative effort of this commission. And I, to Justice Gorman's point, I mean, I can be brought on board, but not with this, not with the state appointed. I think that all judges should be appointed in the state. I don't want that to be confused. But the problem with this particular hybrid is, and why this idea has always kind of went down in the past, is for all the issues that have been brought up. But what if you did, as an interim solution to your long-term goal of integrating the whole system, is doing the full-time elected? Because what it does is it creates those full-time judges, which was part of the resolve, which was the goal of the resolve, was getting full-time judges. It allows the registers to stay as they are. It's a temporary solution. I understand it's not where we all want to be, and I'm willing to sacrifice the long-term goal for that as the intermediate step. But I don't think the intermediate step is this, is an appointed judge and an elected register, with the state paying for rent for courtrooms, for the judge not being able to direct the register for additional days because they can't, for additional hearing days, because they don't have the authority to, or I don't think it's a good model where the Chief Justice has to appear before county commissioners when there's an issue, or maybe not the Chief Justice, but any particular designee they have. It creates an odd model for the operations of the court. So that's why this is not the intermediate step. I'd go with the full-time elected judges as the intermediate step. I could try to get there, and then we go to the long term where we integrate the whole branch over time, so we avoid that enormous fiscal note. I mean, that seems prudent, and it gets us to where we all agree. And I'd like to ask the chairs. It seems to me that everybody on the commission, and maybe I'm wrong, would support the idea of the whole system being moved over to the judicial branch wholesale if money were not an issue. And I think any commission report that reflected that would add some value to potential bills. But that's just a thought.
Thank you. Go ahead, Judge Martin.
Judge Crockett, I guess I tend to agree with your idea about, I think the full-time judges is the most important issue really covered with respect to the reports that we've reviewed. How do you pay for the judge though, if it's an elected full-time judge? Who pays for that?
To Attorney Delicata's point, is the state steps in with that pay, and then this allowing the attorney, the Chief Justice to appoint a chief judge with, so they would have their choice of the 8 judges they wanted to be a chief judge. They would have to review to make sure all the judges performing their tasks. But it's to what Attorney Delicata mentioned with the DAs. The DAs are paid for by the state. The AG's office has a greater relationship with the DAs than they ever did with the county attorneys because of that pay relationship. And that also gets us to that intermediate step of making all the courts more uniform and adding them as full-time judges so they can be incorporated in some of the training that the judicial branch offers as an intermediate step. But you could also offer up the part of the proposal could allow the counties who are already paying a portion of that judge's salary to reduce that portion. So essentially they're saving a little bit of money by passing this budget, this bill, and their contribution would be whatever the difference was would be offset by the state. So that's just a throw out, but at least it would be a very workable bill and would not have a lot of these other pieces that we have to work out in one more meeting or 2 more meetings. So just an idea.
Thank you. Any other questions, Judge Martin? No. Do you mind, Justice Gorman, if I put you on the spot and ask for your reaction to that suggestion that the judges would be full-time and the state judicial branch would be full-time elected, and the state judicial branch would make up the difference in cost?
Well, again, so as you know, the judicial branch does not create its own budget. We, like as Register Ayers talked about, we go hat in hand to the legislature every year asking for enough money to run our current system. If there were some sort of a guarantee that the adding of 8 new judges came with a fiscal note that could not be changed every year, that does away with one of the problems. But there's the, I'm trying to imagine what it would look like when the judges get together for their meetings or for their continuing judicial education and talk amongst themselves with regard to the appointed judges and the elected judges. And I guess it would look something like Judge College in Reno. So that's, again, not an unsurmountable barrier. I don't know, you put me on the spot and I haven't thought about this before. There would be, I don't know what it would look like. It's not anything that I've thought about before this morning.
Yeah, and I apologize for putting you on the
That's
spot.
okay.
Thank you for answering anyway. Representative Cardone?
Justice Gorman, following up on that, when Senator Carney asked you that question, one of the concerns I had is if you've got a judiciary of both elected and appointed judges, is the judicial supervision of those elected judges. I know enough about the organization of the judiciary to know that there are self-monitoring rules, and we get our opinions out by this time. We do this, we don't do that. If there are problems, you can go to the chief, and there are steps that the judiciary takes within its own branch to make sure that judges are doing what they're supposed to do. Would having elected judges create an obstacle to administering that oversight or disciplinary set of rules that the judiciary adopts for itself?
Well, as you know, Representative Cardone, I've been a judge for over 30 years. And when I began in the district court, there were some very clear lines of authority. It would never have occurred to me that I did not have to do what my chief judge told me to do or what the chief justice told me to do. Currently, the model is a little different. I would say there's more questioning of authority, even within the judicial branch. It's much more like herding cats these days than it ever was before. And that's over people whom we have some authority. But the only real authority that the Supreme Court has, or that the Chief Justice has, is to decide where judges sit. So this is a joke, it's never happened, but the assertion is that if you are not doing a particularly good job, you can be, sent to Piscataquis County from January to March, or you can be sent to Aroostook County for the next 2.5 years. That doesn't happen because that's not what we do. But even now, where we are all appointed judges, getting judges to do what we think they should be doing is already difficult. As you know, we can't remove judges. We can take them off the bench, which we have done from time to time. But only the governor can decide to move forward, or an impeachment could happen. Again, not something that's happened. And so we currently have some very, very, very good probate judges. You may recall that in the not so recent past, we had a judge who was more problematic than the current judges. And we had a very difficult time dealing with the actions of that judge. Even if he were more thoroughly under the authority of the Supreme Judicial Court and the Chief Justice, I'm not sure that we would have been able to do anything more with regard to his actions than we could with regard to our the Committee on Judicial Responsibility and Disability, or with regard to our opinion. So it's a very long-winded answer of saying, I don't know. I mean, it's tough now because as Judge Crockett continues to point out, at least on paper, we have authority over the current probate judges. We are supposed to be determining how well they do their jobs, which is impossible. But I don't know. I don't know what it would look like. It would, as Judge Crockett points out, it would certainly be a simpler solution if the idea is only to acquire full-time judges. But for those of us, and I will admit to this bias, those of us who do not believe judges should be elected, it continues what I think is a bad way to choose judges.
I see a couple of other hands up. Register errors, your hand is up, but I don't know if that's residual or if it's a new request to speak.
It's residual. I
Thank you. And Judge Crockett, same question to you. A new request or residual?
No, I actually have a question.
Great, go ahead.
8 full-time judges, what would that cost? I mean, before we added what a county could contribute, how much would it cost to get 8 new judges? I mean, when you think about just pay and benefits, you don't have to pay for chambers, you don't have to pay for any potential indigent legal services, you don't have to pay for any, just the pay and compensation for 8 judges.
About $1.7 million.
So for 1.7, and then if the counties contribute a portion of what they're currently contributing, for under 2 million, we could get there. So no matter what plan we come out with appointed judges, the base number is going to be at least 1.7. And that's before we add in leases, we add in indigent legal services, we add in, all the other issues that are likely to come up, security and all that. for 1.7, even if the counties contributed nothing, we could get 8 full-time judges. And that seems like a very workable solution. That's the only reason I throw it out, because I really want this commission to be successful. I mean, I think this is, I agree with Justice Gorman. This is not the final answer. We need one system that's uniform. Our current state judges are appointed. All judges should be appointed. It should all go in that direction. But I think something is better than what we have now. And that's the problem. And I'm not saying what we have now is terrible, but I would like to improve and at least make a positive step that we can get to. But we know any fiscal note is at least going to be 1.7 million, but we could probably reduce that down and get the buy-in of the county commissioners if we, and that would reduce some of our opposition and actually get a good product. But I don't mean to go on a diatribe this early. I just would like to see a good product come out of here that passes.
Could I respond?
Yes, go ahead. I was just going to call on you.
So yes, if we're talking only about judges and we're not talking about adding law clerks, we're not talking about adding marshals, we're not talking about adding IT people, I agree. But one of the problems that we heard from, I think it was Judge Avantaggio, who was talking about the lack of resources, that currently if he has a particularly thorny legal issue, he's on his own. He doesn't have the benefit of law clerks. He doesn't have, he could call other judges, although I'm not sure how, sometimes that's a benefit, sometimes that's less beneficial. And then there's the relying on the practitioners in front of you. And again, sometimes that's a good idea, sometimes it's a less good idea. But the other problems, and I'm just speaking from my court's point of view, the other problems with the current system are some, we believe, some deficits in the appointment of attorneys, some deficits in the choice of attorneys, and some deficits in the choice of guardians, and even sometimes with visitors. And so it can't be the same. We can't rely on the probate judges to continue to only appoint a few less than wonderful attorneys. If we actually want to improve the system, we can't continue to have not enough guardians appointed in these cases. If we're going to continue to keep minor guardianships within the probate courts. And so it won't just be $2 million. We also would have to look at making sure that if we're changing a system from a part-time system to a full-time system, that the judges have the support that they need, and that they also spend the money that is necessary to provide good and due process to the people who are coming to the courts.
Thank you, Justice Gorman. Those are all really important points, and I appreciate that you raised them. Other comments? Can I put some people on the spot? I'm thinking of you, Leo, if you could comment a little bit about the needs for more funding for the guardians ad litems, attorneys, and visitors. I think that you have a little experience with that.
Well, I certainly agree that there's an inbuilt issue with respect to spending county money for anything. And I think that if, in fact, this plan included general fund money for any of those expenses, attorneys' fees, visitors' fees, which honestly, the visitors' fees aren't going to be a tremendous number. They have one task, and it's a limited task. The attorney's fees, I think, are going to be more than you'll see reflected in the documents that we've received. But I think that going to a system that would guarantee that the general fund would pick those costs up would encourage an uptick in the number of attorneys that are appointed. So bottom line is, I think I I'm in total agreement with making sure that all of these functions are paid for by the general fund. And I'm also appreciative of the discussion that we've had and are having about the possibility of electing those probate court judges and making a concrete plan for a transition to an appointed system down the road. So I will continue thinking about that, but I'm appreciative of the discussion.
Thank you. And Judge Mitchell, can I also put you on the spot to comment about the concerns about needing more resources and more frequently appointing GALs, attorneys, and visitors?
Let me start with visitors because that's a foreign concept to the district court. That's the equivalent of a guardian ad litem for an adult. They're extraordinarily important. It may be a limited opportunity, but when there's an emergency guardianship file, before creating that, you want to know what's happening on the ground. So visitors are very important for the elderly. So it's an expense that I would not want to see fall to the counties if the judges are state judges. Guardian ad litems, we don't have the Department of Health and Human Services with its vast array of child protection, but we get people who are coming outside that system to us asking for a guardian of a minor. So really talented guardian ad litemans, often I'll pick one who's an attorney as well because the issues are so complicated. So that will need to continue, and the counties aren't going to want to pay for that if I am the judge. Much as Representative Cardona said, I think those expenses should follow the judge because it's a court system, but those are critical. The attorneys, it's not, I'm sorry about Justice Gorman thinking they're less than ideal, but it's very hard to get attorneys to work for us for $80 an hour or whatever we pay. So we do the best we can. And but attorneys are required in so many cases. Litigants who are pro se in front of us, we appoint attorneys whenever we have the opportunity to do so. My county has been very generous with that. And you can see from I'm an outlier in terms of how much money we spend on attorneys. But my register and I both know the due process in probate court is absolutely critical because we're taking away people's most important rights. We're putting them under guardianship. So I'm 100% behind Representative Cardone's suggestion that piece follow. I'm not sure I want to wait for another system. If we have the opportunity to move now to a hybrid system, I'm sorry, that makes the full-time state judges really state judges, I would like to try that and still protect the issues of payment of these important services and let the registers do their informal probate and the things they do so well. They don't make judicial decisions. They don't want to. And though when they're helping you with forms, they're instructed, do not give legal advice. You cannot do that. So they don't. They help you with forms. So they could continue to do that. So many wills never are contested. They are intestate. So think of the valuable service they could provide doing exactly what they're doing. And I guess I'm an optimist because we can't do that now. We could change certain statutes to make this supervision work. I don't know what the answer is, but we're not talking about that yet. How do we make it work if we want to? And again, I respect Judge Crockett very much. He's probably right in terms of the expedient answer, but we have an opportunity this time that seems different to me. And I guess I would like to take advantage of it to move forward with these judges and keeping the registers elected. You probably didn't ask for all that. I'm sorry. Thank you for letting me carry on.
Thank you. That was all very valuable, as is everything that we've heard this morning. We are going to hear from Justin Andrus, who's the Executive Director of the Maine Commission on Indigent Legal Services, in just a minute. But before we do, and this conversation that we've been having has actually been a really great transition, but I did want to open it up for those who haven't yet spoken on this issue about, this opportunity that we have to also address, to strengthen our resources and program for appointing visitors, guardian ad litems, and attorneys. Would anybody else like to be heard on that topic before we transition to indigent legal services? And then, of course, we'll come back to our discussion. Please either raise your physical hand or your electronic hand if you have a comment. Okay, I'm not seeing any. I don't think so. Thank you, everyone. And so at this point, Representative Cardone, can I turn the gavel over to you?
Thank you. As long as you keep control of the electronic part of this.
I got it for you.
I'd like to, whoops, I guess I'm still supposed to keep this on. I'd like to take the opportunity to introduce to the panel members of the commission, Justin Andrus. Justin is the executive director of MCILS, the Maine Commission on Indigent Legal Services. And I'll let him explain in a little bit more detail what the Maine Commission does and what their charge is, and how they work. But I asked Justin to come speak to us today with a short presentation, but most important to me, an opportunity for questions by the members of this commission. The Maine Commission on Indigent Legal Services is the state vehicle, if you will, that appoints attorneys for indigent criminal defendants, for indigent defendants in child protective cases, and there are a couple of more as well. I think involuntary commitments. Justin can give you the full panoply here. But as I had been envisioning this process, if our commission were to recommend that all of the payments on the case level in the county courts be paid for by the state, I think that the Maine Commission on Indigent Legal Services would be the entity that would end up doing the appointments of attorneys in our proposal, rather than the judges, the courts themselves, because the court judges no longer appoint, the state judges no longer appoint counsel in these cases. The guardian ad litem and visitor fees would still remain with the courts, and the judges would be appointing those directly, at least as I have envisioned it. But I'd asked Justin to come to talk about that proposal and our charge here, and what he could do to help us, how much he thinks it might cost, although it's pretty short notice for him to get a dollar fee, but just how MCILS works and what we would need to do in order to get it to work in our probate court system. So Justin, I see your name. Are you there?
I am. Good morning.
Good morning. I'm gonna turn this over to you.
Okay, thank you. Good morning, everyone. I am Justin Andrus. I'm the executive director at MCILS. MCILS is an independent commission formed by statute. We have commissioners who are appointed by the governor from a number of constituencies and then confirmed by the legislature. They set policy for the commission. I implement that policy and set procedure. And I just want to start by saying that we have not had a commission meeting since I was invited to participate in this conversation. I'm very happy to do it. And I do think we have a role in what should evolve here. I'm speaking today in my role as the executive director, but without a formal commission resolution as to the commission's position on what should happen. MCILS provides a number of functions. We identify, train, and designate as eligible counsel to receive assignments either from the courts or from MCILS directly for the purpose of providing high-quality representation to indigent defendants. Normally, when we talk about that publicly, the conversation is frequently about criminal stuff, but actually any person who's entitled to counsel under state law or in the state constitution, in addition to the federal constitution, is eligible for services from us. We have an analogous scope of practice already in place, where I think that there's a lot of overlap between what we do already and what counsel do in appointed cases, in probate cases. And when I was in private practice, I did both. So I had some experience with those parallels. But we deal, in addition to the criminal world, with the mental health world, the child protective world, most particularly, and also with the juvenile world. And in all of those places, we deal with the same issues of court action or state action interfering with somebody's exercise of a liberty interest. So in the child protective realm, that's an interference with the exercise of the parental liberty interest, which is similar to what happens in guardianship cases in the probate court. In the mental health realm, we deal with involuntary commitments, and after people have been involuntarily committed, with petitions for discharge or modification of release conditions from involuntary commitment, which is very similar to dealing with adult guardianship and adult conservatorship issues. So I do think there's already a lot of overlap. Many, perhaps most of the attorneys who provide services in the probate courts are also MCILS eligible attorneys. And so a lot of these people are already benefiting from trainings we've done, will benefit from increased trainings we're going to be doing. We're in the process of growing very substantially in terms of our resources and abilities. And so it makes sense to me for there to be consistent practice standards and consistent training when, although child protective and minor guardianship have different names, fundamentally they're very similar proceedings. Standards, legal standards can be a little bit different, but really we're talking about whether or not a parent is fit and when the state has the prerogative to interfere in the parental relationship. So I think that that does make a lot of sense. I did have an opportunity before the session to look at the numbers for the probate court case counts that had gone up on this commission's website. And I did my best to correlate between the case types that the probate courts use and our case types. Forgive me as I click on change what's on my other screen. So, for example, the probate court deals in adoptions and consent surrender adoptions. That's fundamentally similar to when we have uncontested petitions for termination of parental rights. The court deals with contested adoptions in addition to what the probate court calls terminations of parental rights. Both of those are fundamentally similar to what we think of as contested termination of parental rights cases and hearings in the child protective system, and so on. So working from the numbers that were provided through the minutes of I think it was the meeting of November 1st, I worked out a little bit of what our numbers would have looked like if we had MCILS attorneys providing the representation in those cases. Now, before I go there, there's things about the numbers I don't understand. It seems like the assignment numbers, the absolute number.
Justin, can I just interrupt you for 1 minute before we delve into the numbers? I just want to give members of the commission an opportunity to ask you questions about, I don't know how familiar people are with MCILS, but there may be some sort of general clarifying questions or other questions on part of commission members. So let's just take a moment there.
As part of that, if anyone would like and just ask, I can give you a 90-second overview of how the process actually works. People's eyes tend to glaze a little bit, so I skipped it, but I am happy to do it if it's interesting to you.
Could you please give us that 90 seconds on how the process works, and then I'll open it up for questions.
Sure. So there are really two entry points for the people participating. There's the attorney side entry point and there's the client side entry point. I'll start with the attorneys. So an attorney who's interested in providing legal services to indigent clients fills out an application with us, and we vet them for compliance with a set of criteria. The criteria are evolving, but there are criteria today, they must be met. Then then they're fundamentally in our program. Then people can elect to participate in specific case types. So some of our case types require additional training, additional experience, additional certification. The child protective arena is one of those. So an attorney who wanted to do child protective work fills out a child protective specific application, and we vet them for, again, experience and training. And then we help arrange training and even experience through co-counseling if they need that in order to be qualified. We designate people as eligible to participate in our program, and then they're eligible. On the other side, a client who intersects the court process can apply to be assigned counsel in a criminal case. Typically in a child protective case, the court will automatically assign counsel. Come back to that in a second. Mental health case and juvenile cases, it tends to be similar. The client or a client representative, if the client is incompetent, either mentally or because they're a minor, will complete a financial affidavit. We have a set of screeners who review those and make a recommendation to the court. Typically, the court will then determine whether the person qualifies for our services. Services can be provided completely free to the client, or can be, person would be found partially indigent and have a modest repayment plan. A lot of details there that I can skip for the moment about how that mechanics of that work. So at that point, generally speaking, the court sees that they have a case with a client who needs an assignment, and the court will assign a specific attorney from a list of people who have been designated eligible. That's done in the criminal courts under Rule 44. There's some detail there. In the civil arena, which is what would correlate here, it's Rule 88, which essentially simply incorporates criminal Rule 44. So we have the attorneys coming in and getting certified, and then we have the clients coming in and asking, and typically we have the courts making those assignments. MCILS does also make specific assignments. There are occasions where we learn somebody needs an attorney, and for whatever reason, they fall outside that program, and we can make assignments directly from our office as well. I do that personally for MCILS, so I investigate each of those directly.
Thank you. Okay, so before we dive into the numbers that you were about to get to, commission members, are there any questions about the MCILS system or any other questions regarding what Justin Andrus has told us so far? Go ahead, Register Ayers.
I just have a real lack of knowledge on the indigent legal services totally. So I just wanted to know, what is the highest amount of totally court-appointed counsel? What income level do these people have to be at to get a completely paid for attorney?
There are a number of factors that go into it. I don't want to misspeak. I'm embarrassed that I'm not prepared with the answer to that as a pure number. But a person who falls under, I think it's currently 120% of the federal poverty guideline, and doesn't have cash and doesn't have appropriately valuable property, typically falls in. And because we're getting in the details of it, just to add a detail, any person who's subject to first party bail in our criminal system is subject to having that bail captured to pay for attorney's fees, even if they are fully indigent. So I only add that because the real answer to the question is there is the potential for any person to pay some attorney's fees.
I think in the probate world, we have been reluctant to do a repayment system only because of the level of staff that we have and the amount of chasing that we have done. And I think we are a little, I know we are in Kennebec, liberal on that. And that's why on the appointments. And so that's why I wanted to ask you the question. So thank you.
This is not the soapbox I came to stand on today, but I do think that repayment should be outside of MCILS directly, perhaps outside the courts. I'm not sure how that should work, but it's a little problematic. So it's not troubling to me as the executive director that the probate courts might not be doing that collection.
Judge Mitchell?
I'm sitting next to Leo, as I could have asked earlier. How do you interact with other entities around the state who also attempt to provide legal services, like legal services for the elderly or Pine Tree, or how does that all work together, or does it?
It does not work together formally, which is what I understand the question to be. Certainly, we have cooperative communications from time to time with Pine Tree or LSC, particularly recently, most recently, particularly with respect to juveniles in the juvenile justice system. But that's literally it's ad hoc, even if it's not infrequent, because the mission's different.
Anyone else with questions? Go ahead, Justice Gorman.
This is not really a question. It's, I don't think Justin touched on this entirely. MCILS has been in existence for a number of years, but only recently, really, has there been a full-throated attempt to make sure that the rosters for different types of cases are populated by attorneys who are competent in those areas. And so to the extent that MCILS would be adding another roster to cover the types of cases that the probate judges are currently assigning counsel for, and that would be adult guardianships, minor guardianships, and some conservatorships, MCILS would have to and would create a roster that would list those lawyers who have demonstrated the amount of education, experience, and practicality to get on that roster. So it would be, I think it would also be a benefit to the probate judges to have a statewide roster of attorneys, especially now that we're doing things, we've demonstrated that we can do things by Zoom and other remote measures. For example, if the probate judge who were serving Piscataquis County couldn't find a lawyer there, the roster might have someone in your county who could represent the party.
And I think to add to that, and thank you for that, because I didn't get into the specificity very well. And it is very new within my tenure, which only began in January, that MCILS is really adhering to its specific panel eligibility designations. But the flip side to that is you would, as a judge, have the ability to know, first off, statewide, as Justice Gorman says, and secondly, that anybody who is on that list is competent, even if you didn't have the personal knowledge of the attorneys. My experience in the probate courts when I received appointments was that typically I heard from judges who knew me, had appeared before, and there was a lot of attention paid to making sure that getting a person in who could really serve the need of the client in the type of case, which is appropriate to me. But we would be able to provide you with a list of people where we were demonstrating that those folks met those criteria, as Justice Gorman says.
Thank you. Judge Crockett, go ahead.
Thank you, Madam Chair. Also, thank you, Mr. Andros, for appearing today. Fortunately, I was in 2009 when the commission was created. It was contemplated originally that probate judges would, the probate court appointments would be incorporated. I mean, the enabling legislation could be argued that it was supposed to be that way from the outset. I'd had conversations with Mr. Pelletier, your predecessor prior to, about this, but the money just wasn't there to do it. So this commission, regardless of what the other aspects of reform we come to, it seems like we're committed to the idea of at least the appointment process being shifted, or at least the recommendation for the appointment process, no matter what happens with the appointed judges and so forth, versus elected and all that. So one of the questions is there a ratio for administrative costs on an appointment? Like, is there a ratio where you figure, X amount of hours cost this amount of administrative overhead? Because when we try to calculate what that number is going to be, because there's actually bills in the legislature in the last session, or correction, the year before, that suggested that court-appointed attorneys be added to MCILS, which were defeated in judiciary. It would be nice to have this information and be able to put it on the record. So do you have any sort of administrative cost ratios, anything we can use as a planning factor?
I don't yet, is the short answer. It is one of the things we're interested in and planning to poll on it actually in the pretty near future, to try and get that from our folks. I don't want to speak off the cuff. I could give you anecdotally, when I was in practice, sort of what the overhead cost was. But MCILS doesn't pay directly any cost of overhead through its normal system. Instead, MCS pays a rate that's intended to provide the cost of representation, including both attorney compensation and non-attorney costs as part of that. And so as a result of that, we don't track that number. We do, just to be complete, if a person asks for specific paralegal time, they can sometimes be granted that, and that time will be billed through a different system. But it's not a fair look at what the overhead cost is when somebody chooses to do that, specific to that case.
That sounds like a great segue into the numbers that you were about to dive into. Unless, are there any other questions more generally about indigent legal services? Go ahead, Register Ayers.
I didn't have a question, but I did have a comment about the numbers because today I did want to go over some of the information about the numbers. So if Mr. Andros has a question about the numbers, I might be able to help.
Thank you for that kind offer. All right, go ahead, Justin, with your the direction you were headed before we took a little took some questions.
Thank you. Not sure how to interpret the information that I saw through the November 1 minutes in particular, but it seems like there must be a lot of cases to which counsel are not being assigned at all, or that counsel are doing few hours of work per case, or most likely both. So my perspective is that anytime the state is interfering with a liberty interest in an arena where we have the charge of providing counsel, which in my view ultimately ought to be every arena in which the state is doing that, an indigent person is entitled to counsel. And so I anticipate that if we went down the road where we were providing you with counsel, it would likely be that there would be many more counsel and many more cases. And it would also likely be that the counsel will be working more hours than appear to be reported now. And I guess I want to preface what I've done here by saying that, because I think there are two different questions. One is like, how does the cost of the actual work being done now translate if MCLS is doing the work, which is a distinct question from how much work would be done if MCLS attorneys were doing the work. So I looked at the 2018 and 2020 numbers that were in the November 1 materials. I correlated each of the items that appeared to me to be things where counsel should be assigned. I started to talk a little bit about that earlier. And then I multiplied those numbers against my best estimate of what a contested cost looks like. And this is really important distinction, because if you pull our data, which is a lot of which is available in the minutes section of our website, you'll see very low average vouchers. And some of that is because there are cases that don't take a lot of work, but a lot of that is because if two cases are related, the attorneys put substantially all of the billing into one case and almost none of the billing into the other case. And as a result of that, the vouchers come out falsely low. So I've used numbers that more realistically reflect somebody working on a case and not on a companion case that got orphaned. If that was unclear, somebody can flag me and I can try and make more sense of that. But based on the numbers from 2018 and 2020 and the degree of work that we expect under our performance standards for assigned counsel, I've come out with somewhere between $3.7 and $4.3 million in counsel fees, additional to what MCLS is paying now. I do think we should be providing counsel to the probate courts and to the probate court consumers. We can't absorb that. We don't have that in our budget now. So we would need an appropriation to address that. As time went on, if we got closer, we could do a much more accurate fiscal note probably. But that's my best estimate of where attorney's fees would come out.
Justin, is that annually or biannually?
Annually.
Annually, okay.
Do I have the ability to screen share? I'm going to put up my. I may have failed. So I'm going to stop. Have I succeeded in putting the my table on the screen?
You have, but at least from my eyes, it's really tiny. Any chance you can use the little slider in the lower right-hand corner to keep going, keep going. Yeah, that's much better. Thank you.
Let me try and-
And then I'm also going to interrupt you. Justice Gorman, did you have a question that you wanted to ask before we got to the this?
Well, I think it's sort of with these numbers. Justin, since the Home Court Act, the district court judges have been doing adoptions and minor guardianships and name changes. Do you have enough data on the costs of those cases within our system, or is this a sort of a general extrapolation based on something else?
In answer to the first part of that question, not easily, but I think I can pull it. I think it takes a database pull as opposed to my reporting functions that are available easily. And so I wasn't able to prepare them quickly enough for today. In answer to the second part, this column, these are reasonable estimates of what these cases really cost if they're not, immediate compromises and not orphaned companion cases. And so I did this basically against child protective and against mental health, as opposed to trying to pull the home court, probate court stuff out of the district court numbers.
Okay, thank you.
Oh, thank you both. Justin, do you want to take us through this document?
So these were the case types over in the left column that seemed like they would line up with the need for appointed counsel. These were the case counts for those across all of the counties. I didn't break it out by county. These are the nearest equivalent case type. And you see they repeat because from a weak liberty interest perspective, it's more limited than the number of probate court case types. This column represents my, again, a reasonable estimate at our new rate of $80 an hour for somebody really doing work in that. And it could vary wildly. You could have a very expensive contested TPR, termination of parental rights, or you could have one that is contested, but is less expensive for some reason. They're all over the map. And then this is simply the number of cases for the year multiplied against my best estimate of what that would cost.
Thank you. And I guess this is a question, maybe not for you, Justin, but for another member of this commission. Did you assumed that every case would be eligible for a court-appointed attorney or guardian ad litem?
I did. I did that for a few reasons. One, I thought that being conservative in this particular instance meant the higher estimate rather than the lower estimate. And so, give you a warning of where we might wind up instead of shooting very low and coming back and disappointing AFA. And that's number one. But number two, I think most people who are on the defending end of one of these petitions are in fact eligible. My experience, and this is anecdotal, it's certainly not statistically valid, but my experience is the vast majority of people who are going to lose a child to a contested adoption, we're going to lose a child to a TPR, we're going to wind up under an involuntary guardianship. Certainly the parents of those children, they tend to be indigent as we define them by statute. Why? Longer, broader conversation for a different forum. But that's been my observed reality. And I don't have any way to know if that's true in every court, in every instance, of course, because it's purely anecdotal.
Yeah. So let's get a reaction perhaps from Register Heirs and from Judge Mitchell and Judge Crockett on that, because I frankly have no idea whether most of the folks involved in these types of cases would be income eligible. Anybody like to take
well, I would say this, that in terminations of parental rights, that's right. But in guardianships of adults, they are not always contested. And so in guardianships of minors, we have a lot of consented to adoptions, guardianships, especially in a trying time. But terminations of guardianship in the adult or the minor area are labor intensive. And there is usually an indigent person in the minor realm. In the adult realm, it really varies because there are people who have their own, their own means.
So ultimately, this is obviously a decision for policymakers outside of my realm, but from my perspective, any person who's been deemed incompetent and subject to guardianship is not necessarily, even if they have resources in an estate, may need assigned counsel because they maybe or perhaps likely don't have access to their own funds to do that. And so I don't know what the resolution of the cost of the state involved there is. I try not to condition what I think our policy should be on the general fiscal impact, except where it comes to being precise. But I do think that in almost every case there needs to be counsel. So I don't think a consented to guardianship or consented to adoption should go forward unless there's counsel. I think that even if a person thinks they want to agree, I think counsel needs to explain that need. That belief comes from how things work in the child protective realm or certain forms of consent in the criminal realm. And I understand the probate realm is different. But in choosing to include those all in these numbers, that's being informed by that perspective.
Yeah, thank you for that explanation. Register heirs, I think you have another comment. Go ahead.
Yeah, I did. I just wanted to keep everyone to keep in mind that 2020 numbers was a COVID year. And so our adoption numbers were way down in 2020, basically. So I just wanted to keep that in mind, but they were also up in the guardianship area. And I did want to say that the petitions on the guardianship and do ask whether they have their own counsel. And a lot of people do have their own counsel, people with means in guardianship, conservatorship cases. So, and even in uncontested cases, they have their own counsel, not necessarily, they come in with counsel, is what I'm saying.
Thank you. Judge Crockett, your hand is also up. I didn't know if that was with a new comment.
Yes.
Go ahead.
Well, it's part of an additional question, and also first off, I agree with just about everything Register heirs had mentioned. I'd also like to put Mr. Andros at ease that sometimes when you have a situation where someone is consenting, an adult is consenting to a guardianship, sometimes we end up appointing an attorney to just talk it over with them so they understand it fully and to try to get any questions they want answered they might feel comfortable outside of the court to do. And that's obviously sometimes very cheap. It's only just a couple of hours because the person says, oh yeah, I still need this help on this or that. And so we try to protect and a lot of these are elderly. So we try to protect their interests by providing that anyway. So there might be a factor in the numbers on that. But the other piece that I'm curious is on the appointment of GALs, like on our minor guardianship contested, we have GAL appointments as well as attorneys, and the GALs are sometimes attorneys. So we can have 2 appointed attorneys on a case. Are those reflected in these numbers, or is there something I'm missing on the chart?
No, the MCLS does not provide guardian services. And so there's no inclusion here for guardians or for visitors. Also, these numbers do not reflect counsel for any petitioner unless it's a petition to terminate a guardianship. Anyone who is in the position of being the party seeking the state action, I use the word hostile state action, and it's literal from hostile to the right, not mean. But the person seeking the hostile state action is not included here. This is exclusively defending indigent folks from the specter of state action, or at least determining that it goes properly. And I appreciate the comment that people would be called in for, a consult, and I serve that role occasionally in Saginaw or Lincoln counties where I practice primarily. But I do think that from my perspective, a systemic perspective, it needs to be every case. We go down to prenuptial agreements. MCLS doesn't. The law does, requiring informed consent, counseled consent. We look at the Improvident Transfer Act, and disabled or elderly people making transfers to insiders, they've got to have informed consent. It has to be informed by counsel. In the criminal realm, excuse me, we have lawyers for the day providing early support for people who are appearing who might otherwise be self-represented. The legislature just passed a statute that prohibits prosecutors from speaking with unrepresented defendants unless there's a waiver before the court. And courts are using the lawyers of the day to ensure that those defendants are properly advised of their rights, all of which I think is appropriate. And so, again, some of these are culture shifts to some extent, but from my view as sort of being responsible for considering the system level defense function, I think it's appropriate to advocate for counsel in all these instances.
Well, that begs the next question that I've always wanted to see in the probate court was an attorney of the day. Do you pay an attorney of the day, or how does an attorney of the day get paid for?
Two parts to the answer, like so many things. We do pay for the attorneys of the day in the courts where they appear. We also pay for attorneys to represent groups of people in the context of veterans court, drugs court, some other diversionary courts, and that sort of stuff. And we're even going to be expanding that concept a little bit to some other folks like dedicated appellate counsel, or dedicated appellate support counsel, for example. Areas of practice where we see people struggling technically. So yes, we pay for that. However, I think the lawyer of the day concept, as it has been used historically, is problematic, and it results in what is called a horizontal representation, where people have different attorneys at different points in the process, which is inconsistent, particularly in the criminal realm. It's inconsistent with ABA best practices, my view of the Sixth Amendment. And so we're trying to move toward early appointment, early assignment of permanent counsel. It's not always going to be possible. We're never going to get away entirely from having lawyers of the day. In the probate court realm, if there were an attorney who would be there on a day, who was given the lists of folks early enough to genuinely engage and genuinely be prepared, which is really my problem with the LOD system, then something like that might work. And I would be open to brainstorming how to actually make that happen, boots on the ground.
Other questions for Justin Andrus from commission members? Go ahead, Judge Martin.
Good morning, Mr. Andrews. Judge Martin from the Rockland District Court. Thank you for being here. I had a question. Who bears the cost of the financial screeners for the district court? Does MCILS or does the judicial branch pay for the screeners?
The judicial screeners, and I caught myself saying it because we keep saying that they're not the judicial screeners, but they're our screeners. They're employees of MCILS. They're fall under our personal services budget.
Okay, and so if that's the case, would you anticipate additional screeners being required and additional staff from at MCILS to administer the appointments on top of what the cost of the attorneys would be?
I don't know where the work would fall or how much work it is to justify additional screening personnel or not. It is already the case that we don't have screeners in quite a few counties by design. We're down 2 screeners in the counties that we ordinarily have screeners in at the moment. And one of those is Portland and one of those is Penobscot. So they're 2 big counties. And so practically speaking, it's the judges who are reviewing the financial affidavits in determining whether or not a person is eligible for counsel. If we do the internal assignment, I do that myself. So I don't know whether there is a risk, enough of a risk to justify that personnel. I couldn't do it unless the legislature permitted and appropriated additional slots. So if I'm given the staff, I'll use them. And if not, we'll find another way to do it. In the child protective realm, my experience was that counsel were invariably appointed. at the beginning, and then they had to check in and be screened. And it seemed like both the screener on the mid practice on the mid-coast were principally on the not looking at it. Principally, it was the judges who were getting them back. So I don't. Again, I'm not trying to make anybody in particular have additional work. I just don't know whether it would be justified.
Okay, thank you.
Go ahead, Representative Cardone.
Just a couple of follow-up questions to some things that have already been raised. On this judicial screener issue, am I correct that there's at least an attempt in the legislature to try to get those judicial screeners moved? I mean, to try to get the financial screeners moved to the judiciary system as opposed to being in MCILS because of the conflict of interest, correct?
Yes, there are a lot
Okay.
of things in play there,
Okay.
including the judicial branch no longer wanting to be responsible for the collections. I certainly understand why they don't want to do that. So I don't know where that will all shake.
Okay, but as of now, MCILS is still doing the screening.
So as of now, MCILS does what screening it can. For court assignments, it's the judge who makes the indigency determination. Even when a case is screened, the screener makes a recommendation. Judges generally accept and follow that recommendation, but it is always the judge in a court assigned case who has made that determination.
Okay, and then my follow-up question might actually be to register heirs. You brought up the issue of the impact of COVID on the 2020 numbers that Mr. Andrus was using and showed us on his screen. What I took from that is that if we were trying to gauge what's the price tag that we should put on MCILS services, that we're probably better off looking at 2018 numbers than 2020 numbers. Is that, do you agree with that, Ms. Ayers, or am I wrong?
Yeah, I think the 2018 numbers are more, we didn't have a pandemic in the middle of them, so they are different. But the pandemic also increased the guardianships of adults, getting people out of the hospital or out of the nursing home to the hospital. Those numbers did increase. Those adult guardianship numbers did increase, but I think it evens out because the minors decreased a little. Adults went up, but the minor issues, the adoptions, the guardianships did go down in the middle of the year in 2020.
Okay, thank you.
Justice Gorman, did you have a comment?
Well, MCILS and the JB are in a respectful but pitched battle over the placement of the financial screeners. So I just don't want to, we are fighting tooth and nail to keep them out of the judicial branch because the whole idea of court-appointed counsel was moved out of the judicial branch because of both the perceived and the actual conflict. And we continue in that battle to keep the financial screeners out.
And MCILS supports the judicial branch's position entirely. It's a wholly different question from whether MCILS should be in this business either, because of the conflict that's raised there, or whether anyone should be in this business. I mean, the cost of our successful collections against the cost of having the effort made is marginal in the first place. But I also, and it is a pitched and respectful battle, but it's also not one where we disagree with the court's perspective. We don't think either of us probably should be doing it. So whatever that's worth. And I know from an appropriations perspective, it's scary to hear me say, I don't think we should try and support our own budget, but I think it's a huge conflict.
Yeah, thank you both. And I think we're not going to be able to resolve that issue as this commission, and it is not our pitched battle to fight. Judge Crockett, did you have a comment or a question?
Question. So the 2018 numbers of the 4 million, whatever, does that include the administrative overhead calculation, or what percentage of that would be increased by your admin? What do you figure for the administration of that amount of fees? That goes to that ratio I was asking about earlier.
Can I ask a clarifying question, Judge Crockett? Are you talking about administrative overhead for the appointed counsel or an administrative overhead for the commission, the Indigent Legal Services Commission?
Thank you.
MCLI, ILS, their
Okay.
portion, usually there's a ratio for like.
I
Thank
got
you.
it. Should I infer from that that your earlier question was asking for that ratio as well? I answered about the attorney's overhead, but not, okay, so I do not anticipate that the cost of administering counsel in this system would increase our budget at an administrative level at all, unless folks chose to give us additional screeners to help support this. There might be some very trivial costs, like we might put on some additional trainings and maybe we have some additional copy costs. And I don't want to throw away the cost of copying things, but that's not what you're asking. In terms of the need for staffing, I don't see the need to increase our staffing for this reason. We need more people, but this won't change that.
So it could be absorbed within existing resources.
Yes, and existing MCLS staffing resources can do the job they can do whether or not this became part of our charge.
Thank you.
Representative Cardone?
Follow up on that, Mr. Anders. And I know this may depend on the county and the other variables, but if you can give us a rough estimate, if you get a call from a probate register that said, we've got 3 cases here today that we need, I don't know, there are adult guardianships and we need attorneys on these 3 cases. What's the turnaround time in between the time that you get that initial notification and the time that you get an attorney on board for those indigent persons?
It varies wildly, but here are some pieces of understanding that structure. First, we have given all of the clerks in the state courts logins so they can have real-time access to an up-to-date to the minute list of the attorneys who are available to take certain types of cases. And so typically it's the courts making those calls directly, and typically they get responses fairly promptly. Often immediately, sometimes it takes a day. When the courts are struggling to find somebody and reach out to us, we do our best to get the request out promptly. And we have so far not needed more than a couple of days to identify somebody to step into the breach. Until now, we now have our first case that we can't place. It's a criminal case, and I'm not sure what's going to happen with that yet, but we'll figure it out. But usually
I'm sorry to interrupt you, Justin, but your voice was garbled a little bit. Can you rewind just a little bit? And I think you were talking about maybe not being able to appoint someone. We got you through the a couple of days. You said immediately to a couple of days, and then you were talking about an exception.
That's the practical answer. Up to this point, we've resolved all of the apparently unresolvable issues and assignments. At the moment, we have the first case we can't place. And I don't know how that will resolve. But up to this point, it's typically no more than a couple of days.
Thank you. Additional questions? Go ahead, Judge Mitchell.
Just to follow up on that question, it's a very important question because, as you know, the statute requires us when a petition is filed for an adult to have a guardian, they're not deemed incompetent until we have a hearing. And if the person objects, we have to get an attorney. We have to have a hearing very quickly. So it's my understanding that you would be able to do that by giving a list to the appropriate registers county, and they would contact directly. Is that the role you see?
Yes, although rather than we give a list, we will give login credentials to a computer system that will allow the register to identify the people who have been designated eligible to take the case.
And just one more thing, as I'm thinking about your data and your numbers, I think I heard you say, and please clarify, that you looked at the numbers that had been given to you by the registers and the probate courts, and you thought there wasn't a lot of time spent on some cases compared to what your attorney spent on cases. Could you explain that?
Sure. I don't want to try and cite numbers because I don't have that document in front of me.
Right.
I don't want to try and read while I'm talking with you. But I saw at least one document that, for example, said the average attorney hours billed per case was less than one.
Okay.
And to me, that suggests that folks are not being assigned in cases or assigned attorneys, however you want to think about it, in all the cases. So I think I just heard you say that if the person who's going to be subject to the guardianship objects,
An emergency guardianship.
then they're assigned counsel. My view, and I love this job because my liability as attorney was I was very black and white. At least now I have a job where I have a certain very fixed perspective I get to advocate from, understanding that other people do different things around me. But I think even a person who consents needs counsel. I think everybody who could be subject to a guardianship needs counsel. They need counsel on the first day. And so that's, to me, that may be the difference that's driving my observation of the number of attorneys versus what I would have thought I would have seen.
Well, clearly I share your view that people deserve representation. That's one of the strongest convictions I have around this table. But I just wanted to make sure we all understood what was going on in the different courts.
Mhm.
This person objects, they get an attorney, and they come to a hearing, and it is very sad. The statute also requires they have to be present unless there's clear and convincing evidence they can't be. So often I'm looking at a person over at Riverview or in a hospital bed, and they're there on Zoom. They want to be, their attorney is with them or whatever. And the person, he doesn't know, or she doesn't know what day it is, what room they're in, why they're being subject to a hearing. And sometimes that attorney, they have a very difficult job because we have a society of attorneys who are in litigation, warring one another. And here this attorney is supposed to speak for the best interest of the client. And the client says, I don't want a guardian. So we have that tension, which is really difficult, I think, for any attorney to do the job that they're trained to do, as well as making sure this person is not harmed in any way. So that might not take as much time, let's say, as a criminal case or a termination of parental rights when we have to find out so many things. But you clearly have a person who's in deep distress, who needs help with mental illness or whatever. It's so clear from the doctor's report, interviewing the person. So it's not going to take as much time. So I want you to be careful about looking at how many hours our attorneys, maybe less than an hour is a stretch. But I think this is complex. And I just want to make sure you understood how a probate court worked on that as well.
Thank you. I do disagree that the attorney's job is to seek the best interests of the client. The guardian's job is to seek the best interests of the client. The attorney's job is to the extent consistent with that attorney's professional responsibilities to further the expressed interest of the client, unless.
I have to interrupt you 1 minute. The attorney is not the attorney for the guardian. The attorney is the attorney for the person who is going to be put under guardianship. Maybe I misunderstood you.
No, I think it's maybe a difference of perspective, but this is I'm bringing this up not to argue, but because MCILS's perspective is that the rules of professional responsibility, I'm not speaking for the Board of Overseers, our view on the rules is that the attorney's job is to have as normalized a relationship as possible with every client, and to the extent consistent with the rules of professional responsibility, to advocate for the express goals of the client, because it is the client who is allowed to determine the course of litigation. So the reason I bring it up is because my expectation for an MCILS attorney who was advising somebody who was the subject of a guardianship petition would be to advocate for the expressed goal, not for the best interest goal of that respondent. And that might be a little bit different than.
No, I think we're saying the same thing.
Okay.
Because the attorney is advocating for no guardian. And you
Okay.
have a person sitting at Riverview who's a danger to himself or to others. So I'm sorry, I didn't mean to prolong it, but we are saying the same things. I was just not very articulate. I apologize.
I may have misheard. Thank you.
Register heirs, go ahead.
Yeah, I just wanted to chime in there. I do think that just now you saw a difference between district court lingo, who call guardians, guardian ad litems, guardians, and we call guardians. But I did want to say too that, I understand where you're coming from, but I also understand, like, when people are married 40 years and your husband is sick in the hospital and he wants his wife to be his guardian. And, having an attorney come in and try to make it adversarial in a dying family's last days and things is not what people need. It is not. There are cases where it is not needed. We had a case just recently where someone's in a coma. His mom wants to be his guardian. How in the world would an attorney help? They couldn't even probably get in the hospital to see the person. I mean, I understand where you're coming from, but it is not in the best interest of some people to have an attorney advocate for an adversarial roles when we have families who love each other and are trying to do the right thing for their family. Not always.
I think that there's a difference between recognizing that the attorney has to be prepared to participate in an adversarial process and an attorney who behaves in a personally adversarial manner. And especially when I was a young attorney, I didn't always know that distinction. I don't claim innocence on that subject, including in your court, Register Harris. And before yours, Justice Gorman. But I do think that there's a big difference there. However, before we get to the question of best interest, the law court has made it very clear in the child protective context, for example, that we have to get through the question of fitness, which is the trigger for the state intervention. And I would say the same thing is true here, that an attorney needs to assess and be prepared to represent the client on the issue of competency, for example, before we get to how do we resolve the situation in the best interest. And for that reason, I think even in the scenario you described, there needs to be counsel. Now, hopefully counsel says this person's in a persistent vegetative state. We don't need to have a war. I completely agree with that. May I answer to something else, since I did find what I had seen earlier?
Yes, and we're just a few minutes from our break. So if you can address that, and then we'll see if there are any final questions for you. Thank you.
The document that I was talking about earlier is in this meeting set, and it's for discussion only cost estimate, but somewhere in there, second page or third page, it says something like, here it is, there was a 0.0426 appointed attorney's hours per case. And so even if we're talking about the difference in practice environment, that's still a lot lower than I would have thought would likely be the case. And again, the only reason I bring it up is I do think that there will be a substantially increased cost to having MCLS people do this. I think it's appropriate. I think we should be appropriated for it, and that we should serve that role.
Thank you for providing that additional information. Commission members, we've got just a couple of minutes before our break. Are there any final questions for Justin Andrus? I'll look first to folks who are participating remotely. I'm not seeing any questions, and those in the room here. Representative Cardone, did you want to make any closing remarks about this segment of our day today?
No, just a personal thank you to Justin Well, and thank you on behalf of the commission as well for your time here today and for the time that you took to put these numbers together. I do expect that if there is a recommendation by this commission that MCILS, or that the state absorb the costs of attorney fees, that MCILS will be called upon in the regular session when we've got this as part of our legislative, considering bills and legislative process as we try to refine what those costs may be and ultimately end up with a fiscal note. So I ask you and your commissioners to stay tuned, and we thank you very much.
Thank you for having me.
Thank you so much. And commission members, that brings us to the conclusion of our morning session. And as we've done for our past two meetings, we're going to take a relatively short lunch break and return at 12:30. We will continue our discussion from this morning. And I also wanted to let members know that during part of this afternoon, at least Professor Smith, who did present to us at our first meeting, is available if we wanted to ask Professor Smith to answer some questions. And so with that, we will take a 30-minute lunch break and return at 12:30. If you are logged into the electronic meeting, please remain muted and also turn off your camera. And we'll see you at 12:30.
Would you like to know next?
Good afternoon, everybody. It looks like our 30-minute lunch break flew by, and we're going to reconvene for this afternoon's meeting of the commission. And thank you, everyone, for returning so promptly. So this afternoon's agenda is a discussion and vote on the probate system model and recommendations. And we began that discussion actually this morning between 10 and 11. And I feel like we had a very robust discussion. There is one piece of information that was referred to a couple of times, both in that discussion and also when we were speaking with Justin Andrus, and that is the document that was created by the OPLA analyst, Sam Seneft, and it is the estimated costs and savings probate court reform. And it's a draft, it's for discussion purposes only. And just to put it in context, oops, I didn't activate my camera. To put it in context, this morning when I was referring to the Office of Fiscal and Program, I think it's called analysis, but review, thank you, OFPR. We will, as this, the work of our commission moves through the legislative process, we'll get a very granular fiscal note. This document was prepared with a lot of hard work by Sam in order to help us kind of get our arms around part of our charge, which is to come up with a way to pay for the model that we propose. And so I think it makes sense at this point, and I'm turning to Representative Cardone because I didn't run this by you, but what I think it makes sense to do at this point is to turn the floor over to Sam and let him review with us this estimated cost document. And then we can ask him any questions. And Sam, is that a good procedure from your perspective? Okay, so I'm going to turn the floor over to you.
I'm going to just interject here. And yes, that's the, I think that's exactly the way to go. During this afternoon, we may be taking one or more votes on which direction we'd like to go, or what we'd like to incorporate, what we'd like to leave out, to help steer our analysts as to how they would like to, how they could put together a draft that we can then review at our final meeting. We discussed how best to do this voting, and especially for people who aren't here or aren't able to participate. So we had 2 or 3 people, I think, who were unable to participate today. We did decide that if you are unable to participate today, unable to take a vote, that we would give you 24 hours, and we'll send this, make sure everybody gets an email on this, that we'll give you 24 hours that if you wish to weigh in on the vote, I'd ask that you please email our analysts, Janet and Sam. You can CC Ann or me, but I'd prefer that I wasn't the only person getting a copy of your email. But Janet or Sam, or both of them together, and they will make sure that your vote is counted in with the tally, so that we know which directions that we've all decided to take. That's all. Thank you.
All right. So I think Janet is going to screen share this document, if that's okay, so everyone can see what I am referencing. So for folks in the room, it's this green document that has the weird watermark, which only picked up half of the letters for some reason. So this is a document, and it is not meant to be a fiscal analysis. It's not meant to be a budget. It's meant to be a guideline for discussion, to give the commission some ideas about what kinds of costs and savings for the counties might be part of a transition like this. I did build a bunch of assumptions and limitations into this, and I did note them where I did that at the very top of each section. So I will just very briefly go through this section by section to let you know kind of what I was thinking, and some of the things that you might want to consider as you move forward. The first section here is potential costs to the state of the proposed system. Probably the easiest thing to cost out here were the judges, because we know what those costs are. So assuming that there are 8 full-time state probate court judges, and looking at all of the associated costs, you're looking at a little south of 1.7 million annually. For the 8 judges. Similarly, clerks, we do know what those costs are, because we were provided that information from the judicial branch. So assuming that the probate court judges would be served by a total of 2 law clerks and paid at the same rate as the law clerks serving the other trial courts, you'd be looking at a cost of about 215,000 a year. This does include, this is a tiny thing, but it does include $6,000 in training, and I did build in those costs because those are first year costs, but most clerks are only serving for a year, so you can assume for most of them that would be an annual cost because they're new each year. There was also an initial training cost for judges of 12,000 a year. I did not build that in to the total cost because judges are typically serving longer than a year. There are other positions certainly within the judicial branch that may or may not be included in this transition. That could include various types of administrative staff, court marshals, IT staff, custodial staff, and others. We do have information for some of these, what some of these folks typically would cost. I did not go so far as to trying to assume who you may want to include in the transition. I did make a note just to give you a benchmark. We do have costs for a deputy marshal at a step 3. That's the human resources range. That would amount to, including all benefits and mileage and training, $91,775 a year. So appointed attorneys, this is where it gets into a lot of guesswork, as Mr. Andrus was discussing in his presentation. So you'll see my numbers look different from his. I think there's also a good reason that they look different. When I went through this, I did not want to assume in any way how many cases would involve appointed counsel. So what I did was I looked at the caseload data, the 2020 caseload data from the registers, and tried to give a range by taking the data that I did have on kind of either extreme and extrapolating it out. So the first thing I did is I looked at Lincoln County. Lincoln County reported only 20 court-appointed attorney hours in 2020. They also reported a caseload of 470 cases. So I calculated out a ratio, and then I extrapolated it to the total probate caseload for that year. So if you were going to say that attorneys would be appointed at the same rate that they were in Lincoln County as 2020, you would end up with the rather low cost of $43,680. So that represents one extreme. And I think it's safe to say that is a pretty extreme. At the other end of the spectrum, you had Kennebec County reporting 212.7 attorney hours, appointed attorney hours in 2020. And they had a caseload that I was able to use to extrapolate, again, a ratio, and then take that out and apply it to the total caseload for the state. If the state appointed attorneys at the same rate that Kennebec appointed attorneys in 2020, you would end up with a cost of $165,680. That is not, of course, the whole story, because there are, as Mr. Andrus described, you would expect that there would be a lot of factors driving differences in attorney appointments at the state level if you had a statewide judges than if you had than in the current system. Also, again, this was 2020 data. There's the pandemic, and in some of the cases you had impacts, I think more heavily than others, as Register Ayers mentioned. So what I think you can take from this is that there are a lot of unknowns here. Once you have an idea of what your caseloads might be, you can certainly cost out what you might expect. And certainly when you have a bill in front of judiciary and OFPR goes in and does a detailed analysis, they will look at things like this and they will come up with certainly better estimates than I can. They'll have some more time to look at some more data and to potentially work with MCILS to figure out a tighter range. But what my purpose here was to show you that there are a lot of variables, there are ways to calculate it. And here's what we look like if we just take what we have now without taking all these other factors into account in trying to figure out what, how those costs might change and likely increase. I did a very similar analysis with GALs. Here I was, there are assumptions I do want to point out. I was assuming a rate similar or the same as the current MCILS rate of $80 an hour. That is a significant assumption to make. But just for the purpose of getting a number, that is what I used. So again, you'll see significant differences here. Kennebec County, using the same process I did with the judges, I came up with a total of $55,680. But if you go to, I'm sorry, I can never pronounce Sagahadak. I think I kind of got it there. So if you use their data, you would come up with a much higher number of 251,200. So again, it is a fivefold difference. So there's a lot of variation by county, but then there could also be significant differences caused just by the transition to a state system. Visitors, I didn't have any I didn't have information I felt comfortable relying on in terms of the payment rates for visitors. But I would point out that, again, you would see significant differences by county. Kennebec having high rates of visitors and probably reflective of the hospital being in the county. But you could do a similar costing outs if you did have those numbers of what is being paid for visitors. And then for just other things, I just kind of wanted to list out other things to think about: facilities and supplies that may or may not need to be accounted for. So obviously building, leases or rents, maintenance costs, utilities, supplies, technology, equipment, mailing costs, all of those things are things that, again, OFPR, when they do their formal fiscal analysis, will try to look at to the extent that information is available. So on the other side, of course, there's savings. So if the state is paying judges, the county is not. So the data in this green sheet was the salary data we had from 2019. Judge Crockett had kindly sent along some new data, which I didn't get to paste it into this document, but I did. If you're in the room, you have a purple sheet with some updated salary and other compensation information for the judges. And that was emailed out to you if you are on Zoom. So there's some differences there. And I think this new data provides some more information on compensation that is beyond salary, so benefit information. And there is some variation by county on what benefits are paid and which judges choose to take advantage of certain benefits. So there might be other positions as well, savings that are concurrent with the savings for the judges themselves. Court appointments would, again be another source of savings, as would facilities and supplies costs. So that is the other side of the coin, certainly, to moving the courts over would be a savings in the county side. So that is this document. Hopefully it will be of some help as you continue your discussions, and I'm happy to try to clarify anything or answer any questions.
Thank you very much, Sam. And we do have some questions. Register heirs, do you want to go ahead with your question?
Yeah, let me start by saying now I understand what the issue is with the court-appointed attorneys. You used the total number of cases from the caseload, detailed caseload. The amount of court-appointed attorneys is only going to be from the adoption and guardianship area of cases. So instead of 1,600 cases, we are talking 365 cases. So that's an issue, because in estates, we do not do court-appointed attorneys. And in the informal area, there is no judge involvement. There are no appointed attorneys. So those numbers are need adjusting.
Yeah, thank you. That's super helpful information. Sam, did you want to follow up?
Yeah, and I do recognize that, and I did recognize that as an issue, without knowing which counties were appointing attorneys for which cases. I just used the full denominator. And again, this is why I really don't want people to rely on these numbers for the purpose of numbers only, but more as an exercise in how one might come about trying to come up with a budget. But I absolutely appreciate and agree with that those numbers shouldn't be relied upon for that purpose.
And could you just please, because I was listening and not taking notes, can you just recite for us the cases that actually do get court-appointed attorneys again? Thank you.
Okay, it's the adoption cases.
Mhm.
And it's the guardianship cases and the conservatorship cases of adults and minors. Those are the cases we do court-appointed attorneys on. We don't do them on estates, because if an estate is in controversy, there is money to be taken from the estate. And then the informal area, which is in my court, it is 781 cases. There's no court-appointed attorneys in estates. And then, it's possible that it could be in a change of a name of a minor, but it has not been done. But it's the adoptions and all the most of the guardianship area. But things like accounts, we counted in there, and those are not something that, well, I won't say it's never been done, because we've had some bad accounts and we've had to have an attorney before. So I guess you could do them all, but all the proceedings that are guardianship, which are, close to 3,000 in the state, those are the ones that are going to be have your court-appointed attorney. Trusts here. You also have a thing called, you would not formal all other. That's the kind of what I wanted to go over today. And that's for some reason it's in the guardianship area, and it should probably not be in the guardianship area. Formal all other is a lot of things. It's undue influence cases. It's remains cases, custody of remains. It's temporary restraining orders in estates, complaints regarding real estate. It's a lot of things put into that category, but it should not be in with the guardianships. And that says 488 cases too. So your court-appointed number is going to be a lot lower than, and now I know why our percentage is so low on there. So.
Thank you. That also is incredibly helpful. And I know that you weren't able to attend our prior meeting, and you sent a great stand-in, but it just struck me when you were explaining to us the formal all other that maybe there are other things that you think we should know about that we either don't know about or we think we know, but we're wrong. Are there other things that you'd like to set the record straight on?
Well, no, I mean, I heard Judge Crockett say that, your conservatorship that is goes into an estate. In other words, the conservatorship that too would be in there. So sometimes the all other is that conservatorship that has gone into an estate. The thing that I'd like to set the record straight about is about the system, the computer system. I'd like to say that, and I got to try to be very as nice as possible here, but we get our numbers from proceeding codes in the system. The proceeding codes are generally, in my court, they are generally the form number of the petition. A lot of this comes in, the attorneys are putting in the proceeding codes or the names of the petition. If they go off the form list and they put their own wording, let's say, and they're one word off, it may not show up on the proceeding codes. And then we have to do a different kind of search for things. We have to do it by word, adoption. We put the word adoption in and we'll get some things. But when it's e-filed, sometimes it's going to say it will throw your proceeding codes off. And I call it garbage in and garbage out. If you don't put it in there right, it may not show here. So it's very time consuming to do it, change it on the way in. And that is what we try to do. But this is not a matter of our system is not proficient or our people are not proficient. It's a matter of, again, staffing and timing to do these cleanup things that need to be done when the data comes in. And I know there was more that I wanted to say on that, but also our form numbers all changed. In 2019 and deep into 2020, our form numbers were changed and our codes, and it may not seem like a big deal to somebody, but when you have the district court forms and rules come not talking to the probate rules about, I'm going to change all your guardian forms to GS, let's say. It's going to throw off your numbers, and there's going to be a lot of things that you have to do to change those. It's not that it can't be done. It's just that it's time consuming. And unfortunately, the probate courts are emergency driven. We have a lot of emergencies. So that's just kind of something I wanted to say about the numbers. And, I kind of laughed a little when I saw Justin Andrews, because he might be the one that when you tell an attorney, you didn't name that right, so please do that, you can expect some grief back. Let me just say, you can expect some grief back. And, but it's really an important thing. And after I talked to the registrars, I thought maybe something that needs to be put on here is that attorneys need a little more training on their side of putting the information into us. And yeah, I think that's all the records need right now, straightening.
Thank you. Thanks very much. Okay, so Sam, go ahead.
I just wanted to note, Register Ayers, I will make a note. I will adjust this form, the cost form, and make a note that is reflective of your comments, that the denominator is not an accurate denominator or reflective of only those cases that would actually have court appointments, and that the numbers are going to be low because of that. So I will amend the document accordingly to make it that clear, that limitation.
I appreciate that, and I appreciate all the work that you do with the shooting in the dark we're doing here.
Thank you. Thanks you both. Okay, so we do have some clarifications on the table, but are there any questions about this preliminary costs for discussion, estimated cost for discussion document, or any other comments or questions or discussion about the cost end of what we're about here today, coming up with a model? Go ahead, Judge Crockett.
So when we have some sort of rough idea on the facilities maintenance and all of that portion, what's the plan to get those numbers sort of pinned down?
I think that the plan would be first to come up with a model and to have an idea of the contour of what the needs would be for facilities and those other aspects. And then ultimately, it would be up to OFPR in the context of the bill emerging from committee with a report, that OFPR will take that report and actually do the granular analysis of what the costs are. That's not something that we as a committee can do. What we're trying to do is to have some understanding of kind of the general significance of the cost for the different categories, so that can inform our decision on the model. But it's we're not going to be able to get down to the nitty gritty during the course of the commission's work. That's really something that happens once the legislation passes out of committee. Go ahead.
Oh, sorry.
I agree with that. It was never my intention that we draft this report with something akin to an accurate fiscal note attached. But I did think it was important that we understood at least the round figures, the ballpark for these numbers. So we can decide based on what a fiscal note is likely to be. Do we want to make this recommendation? Do we think that's going to be too expensive and not get through? I just think it's important for all of our committee members, our commission members, to have some sort of a basic understanding. But I don't think we're ever going to be able to get to the level of an accurate fiscal note on all of this. It may be enough that we flag those issues for the actual calculation of a fiscal note by OFPR. That was at least my intention coming into this exercise.
Additional questions or comments? Oh, go ahead, Justice Gorman.
So with regard to the cost of the guardians, as Justin Andrews indicated, the judicial branch currently pays for guardians ad litem. And I'm cognizant of Register Heirs reminders that we can't conflate guardians and guardians ad litem. So I'll try to stick to guardians ad litem, GALs. We have paid for that despite our request year after year that the legislature also removed that from us because we also perceive that to be a conflict. And that is currently costing the judicial branch approximately $3 million each year. And so we have to include in any kind of even a general fiscal note, an additional amount of funds if the judicial branch, regardless of whether the judges are appointed or elected, is going to be responsible for paying for guardians ad litem assigned by the judges.
Thank you. And can you turn on your mic and make that comment?
Yes, I agree with that. And we're also going to need to figure out what to add in over and above guardians ad litem, what to add in for visitors. Because they are somewhat different roles, and we don't have a comparable visitor's role necessarily in state court. So we are going to have to look more closely at that. But yes, it was, again, at least my intention that all of those costs be brought into the state court rather than being left to the counties.
Is Judge Mitchell or Register Heirs or Judge Crockett? I don't have any concept at all of what the hourly rate is for a visitor, whether it's, what the range is or if there's a set rate. Can you illuminate that, please?
Yeah, I can, if it's okay with the judges.
Go ahead.
Because we have to have visitors with specific case-related expertise. We may have as low as $35 an hour. They bill out to, and this is one of the things that we are not uniform on, and it has to do with your budget and how much, how much money that you have in the system and where you are in the system. Penobscot with Dorothea Dix and us with AmHi and Togus, we sometimes have to have very sophisticated visitors who have PhDs, and they will charge their rate. It's, like I said, it's billed to the people. If the people are indigent, then we end up picking up the tab. So there can be as much of a difference as $35 to $200 an hour. And it depends on the situation of the guardianship. So that's a real tough one. I think the bottom end of it, the people that we use, retired nurses, I have a school administrator who has a Down syndrome adult child who does them for us at like a $35 rate an hour. But we do have some specialized visitors that cost quite a bit more.
Go ahead.
Kathy, who determines what the specialized need is for the visitor? First of all, is that a statutory requirement? Okay. And who makes that determination? Is it the judge or the register?
No, the judge makes that decision, especially, these are usually highly contested AmHi cases or situations. And someone to wade through that system. Luckily we have a couple of very specialized people.
Okay, thank you.
Are there some, I'm going to just keep asking you questions if you don't mind. Are there some probate courts that don't use any visitors?
No.
Some counties?
No.
What are some of the other examples? You said that a highly contested AmHi case might require a visitor. What are some of the other situations in which a visitor is required?
Sometimes, we have nurses. We have nurses that will do, a specialized medical case in the hospital that is above a normal person who is just doing the interview to get the information. They may have to dig deeper into the medical terminology and that sort of thing.
Thanks. That's helpful in understanding the visitor's role. Other questions either about the visitor, or if not, then other questions related to the cost estimate? Go ahead.
If we're considering, let's just go back to Judge Crockett's, the elected judges and keeping the registrars where they are, wouldn't the county still maintain the funds or the costs for the facilities and supplies? Where does that change? How does that change anything? Because don't they fund those at this time? I guess I'm not sure who can answer that, but I'm not. So for example, let's say the state provides a judge for two different counties. The probate court remains where it is in both those counties. The judge shows up. What really what would the state be doing in paying for something that's already being paid for? And so I guess I'm confused at what the facilities and supplies, why that would cost the state that money. If anyone can answer that. But.
Well, John, it's because the counties give nothing free to the state. In every courthouse that is owned by the county, the state of Maine is paying rent, including in Cumberland County, despite the fact that we paid for that portion of the building we are currently housed in. So every time the state uses space in a county building, we are required to pay rent by the county commissioners.
So, but the existing probate court, that the state's not paying that right now, correct?
Correct.
So why, I guess my question is why would that change if all we're doing is providing judges?
I can't answer for the county commissioners, but I can suggest, based upon some of our dealings with them when we are building new buildings, for example, that we will no longer be able to use what was built as a probate courtroom without paying for it.
I see.
Jared, do you disagree?
No, as always, I typically agree with you, Justice Gorman, but in this particular issue or instance, I also add that the full-time elected version, we're not paying for. So that's one of the reasons why I'm coming at it from that, trying to narrow the fiscal note, because my tabletop math still gets me to between over 10 million with everything added up. And I'm afraid that's a death sentence. So but your point's well taken, and why we could avoid that whole facilities costs and expenses and rent and the entire argument that goes along with it, which is rather lengthy and probably a little bit trying for those involved. And so I have sympathy for you, Justice Gorman.
Judge Mitchell?
Judge Martin, your very question points to my confusion. We started out talking about a model that we thought that most people decided on. Judge Crockett presented his position today, which was quite clear. So it seems to me, but it wasn't quite clear, because I want to know if the elected 8-member judicial probate panel is still county, or is it in the state court? Because we're either talking about Judge Crockett's model or the model that's on the table. And I think they've gotten mixed together, and it would be helpful to me to understand. So first I need to understand what Judge Crockett's proposal is, if that's okay with the chairs.
Yeah, I think that's a great place for us to return to in order to have a more robust discussion about the models. And it sounds like we may have 2 models that people really want to vet. And so let's start, Judge Crockett, if you could again walk us through your model, paying particular attention to, like, the judges we understand will be full-time, but who will they be getting their paychecks from? And yeah, if you can just kind of take us through your model, and then we'll return and look at the other model that's on the table as well. Thank you.
First of all, I'm hesitant to become the lightning rod that all things are pointed at. And I always hate to have any model named after me.
We're all friends working together on this. You're not going to be a lightning rod.
Yeah. So my thought, and this was just 10,000 foot proposal, is you do the probate judges based on, make them elected, based on the DA district, so there's no dispute. You're going to have to give authority to those judges to sit. That means they'll be regional, but you'll also have to give authority to those judges to sit in other courts because of vacations, illness, so forth. We currently have that under the existing system. The Chief Justice piece, that it's been kicked around for a long time amongst probate judges, is there should be some sort of oversight mechanism that if there's a judge who isn't being responsive, or if there's a problem, or if something's coming up, that there needs to be a chief judge of some sort. We've always sort of, I guess, we've policed ourselves to the extent possible, but you've heard about some of the other issues. I think Justice Gorman alluded to one earlier, but some chief judge. So out of the 8, the Chief Justice would choose one as to act as a chief judge, essentially. So that would give us a segue for further modification down the road, or further amendment, part of that long-term integration into the judicial branch that should eventually happen. It would also help on standardization. Obviously, the authority of that chief judge would be somewhat precarious, like the herding cats, but it would at least be something more than currently exists. And it could be done on, I hate to say on the cheap, but compared to the numbers I'm looking at, I think cheaper than other options. I think you get there for the 1.7. I think the state kicks in a portion of the 1.7 cost, And the counties, because they're currently paying X amount for a probate judge. In Oxford County, I'll use my own as an example. I think my wages are like 30 something, and health insurance and a partial retirement for 1 day a week in court and being on call 24/7, but being on call and not necessarily being in court all the time. So the county, if they kicked in half of what my existing salary was, right? If each county in my DA district has 3 counties. So if each one of the counties kicked in 45,000 to come off the expenses, or correction, if collectively they kicked in, 15,000 apiece, or 50, 60, some sort of number, that could reduce the implications of the fiscal expense for the overall. Now, the state would end up paying, and like Justice Gorman said, it would have to be essentially the same way we do district court judges, where the state can't then cut that funding at a later date. It would have to be integrated. And this allows us not to touch the registers at all. We don't have to change the relationship. The judges that can currently add a court day, I have the flexibility to say, yes, I only have court 1 day a week, but if I need an extra day for trials, if I need 2 extra days, I had to clean up a lot of things when I came on the bench, and I had to add a whole bunch of court days. I could direct the county employees to do that because the county elected me to do that. So we still maintain that authority relationship. And the registers who still run the day-to-day operations, they still run the clerks. We're still paying clerks at what the rates the counties are currently doing, rather than any sort of state level. And then you really don't have to touch any of the facilities piece. You don't have to touch the indigent legal services at this time. I still think it needs to be dealt with. I supported the bill that Senator Davis put forward last year, that the appointed attorneys in probate court should be part of the indigent legal services. But if we don't want to tackle that, but we want to get full-time judges as just a step, because it can be done so cheaply. Now, I know that I'm not going to be one of those full-time judges, more than likely, but it's a good step. And I'm saying this, I think it's something, and it's very realistic. And if you want more particulars or questions on, like, the fees would stay with the counties, they'd still collect their fees. The visitor system, we're still working out the details on the new probate code, where there's greater requirements for visitors now with training and education than there used to be. We're still working out some of those issues, but at least it gets us full-time judges, which was in the resolve as one of the stated goals.
Okay.
But if someone has particular questions.
Yeah, there are lots of questions, so I'm sorry to interrupt you, but we're going to start with Judge Mitchell and then Justice Gorman.
First, a clarifying question. Are the judges, county judges still, although they're 8 and they're still elected and full-time, or are there 8 elected judges that are on the state district court? I didn't understand your proposal.
They would still be counted under Title IV. They would still be the same. The only thing that would happen was their selection process under Title IV would be different.
They'd be on the state court, under the state court.
They'd still be county. There'd still be a county court, so you wouldn't have to worry about that expense.
No, I'm talking about the judges only. Where are the judges?
I'm telling you, it's going to be a county court full-time.
Okay, so not part of the state system at all, really. It's just same as we have now, except fewer people who are not elected and they're working full-time and not practicing law. Is that your proposal?
So,
I'm sorry, they're elected, but they're full-time and not practicing law. Thank you.
Right, they're still county, and that's the segue
Okay.
to the state
Nothing
system.
really changes. It's more the DA model that you see. Is that
And we
correct?
get the full-time judge, yes.
Okay, that you've answered my question. And I apologize for being so rambling about it. Thank you.
I actually had the same question. I'm glad you answered. So a clarification. So in some of the districts, one judge would be hired by 2 counties, for example. Is that under this model?
Correct.
Okay.
I'm just using the DA model as an example, and I'm not saying that's the greatest use of balancing, but I can say there's a practical relationship there already amongst the counties that would be part of the districts. And so it is a moderate step towards the total integration.
May I just-
Thank you.
It just might help you visualize Kennebec County and Somerset in their same county. And maybe you could ask,
Yep.
them so you get a picture of what we're talking about.
Great. Yeah, thank you. And we do actually have in our materials handed out today a great, I think, did Professor Smith do this? It's a, for those, there's a map that actually, never mind, this is a different map. This shows when terms are expiring. You're right, I was mistaken about that. Okay, Justice Gorman, go ahead.
So I don't know if I'm espousing a position or asking a clarification. If we're trying to do something that allows for full-time judges, which is our task, it would be very simple to create regional full-time probate judges who continue to be elected, but are not working as lawyers, which takes care of one of the biggest problems, or at least one of the biggest perceived problems. But then we're left with the idea that the other problem that we're trying to fix, at least from the judicial branch's point of view, is the lack of consistency and the lack of anyone to go to when there's a problem. And that, as Jared points out, could be fixed by the naming of a chief judge of the probate courts. And I don't know if I subscribe to this or not, but the way that the federal judges do it, as you know, is they simply rotate. So right now, John Levy is the current chief of the First District Federal Court. And it was Judge Dorson before, and it will be Judge Walker at some point in the future. So at some point it rotates through without the idea that any one person gets a lifetime tenure and becomes a dictator for whatever it's worth. But I'm very reluctant to say that elected judges should then somehow come under the umbrella of the state system for any number of reasons. But one of them, again, is it doesn't fit. We don't currently have elected judges in the judicial branch. We frankly don't want elected judges within the judicial branch. We would like to continue to be appointed judges and think that that is the best way to choose judges. So if we are going to be thinking about a model which continues the elected judges as full-time positions, I think they have to stay within the county system. And then what we have to figure out is how to create a better way to fund the systems, and whether that's an infusion of monies by the state or a requirement that the counties fund them adequately, and also figure out a way for some control is the wrong word, but some way to make sure that the judges do what they need to do, that the registers have what they need to do their jobs, and that there's someone to go to when there's a problem. Because right now, everyone is a lone ranger. And although we currently don't have any problems, there certainly have been problems in the past where one judge was unwilling to work with the other judges, and some problems where the judges and the registers get into a pitched battle. So it's the lack of consistency, the lack of control, the lack of any one or two individuals who could actually affect change should change need to be affected. So that's my pitch.
May I respond, Madam Chair?
Thank you. Hold on a second. Register Ayers was next. Her hand is up, and then we'll return to you. Go ahead.
Just real quickly, I just wanted to ask the question about, I think Judge Gorman answered the question for me. It's the training piece, the fact that we're not allowed, we don't train with the judicial branch, and the judges don't train with the judicial branch, and they really, I do believe they wanted that. And also, we're talking about registers a little bit here too, that some of the non-uniform things that happen because of the different ways that counties do their budgets and how they run it, how they run their fiscal and calendar budgets. And I don't think that can be overlooked.
So can I just ask you a question, Register Ayers? Is it your position that this, so we'll call it model Model B, that Model B is not workable?
I'm a make it work kind of person, but I'm just saying that, the fiscal challenges, the differences between the counties have been an issue and are an issue in some of the uniformity that attorneys are upset about, the things like how abstracts are paid for when they go through the system, or how I had another one but it went off the top of my head. The abstracts, the way visitors are paid, that's all different in a lot of counties because of the way the management of the county wants the money coming through. So,
Okay, thank you. Judge Crockett?
Yes, Justice Gorman alluded to the truth of the matter is we've got 16 silos, 16 different county courts. And what I'm going to say Plan B here, or Model B, looks at bringing it down to 8 silos, which is not perfect, but it's better than 16. And there now is one step towards uniformity because you've got 8 different judges dealing within the system. I'm not saying it's the end result, or what we really want to end up with in the long run, but slowly these systems, like eventually the ICON system needs to be rolled into the state system for e-filing. There's got to be a lot of pieces that take place. I think this is just a moderate step. That's the only reason I propose it, and it would avoid a lot of those battles because now it's the state contributing to county judges, just the way the state contributes to the DAs, which are still county elected officials, or the state contributes to the county jails, or those types of things that we're getting a step further, and we're getting a full-time professional bench, which is what we want. Because I'm not sure if we'll get there with the Model A, I guess, if you will. So, and I yield the floor.
Justice Gorman, did you want to respond or provide additional information?
Well, to Register Ayer's point about the judges needing training, there was a request by Judge Crockett earlier last year that the judicial branch provide training for the probate judges, and we declined because we cannot educate some lawyers and not other lawyers. And although they are judges, they are also lawyers. And so as long as they are part-time and continue in the practice of law or allowed to, we cannot train them because we can't be in the business of training some lawyers and not. If they were full-time judges elected, even though they are not considered to be state judges, we would be able to train them. The training that they get from us might look slightly different than the training that is currently provided for the district courts and superior court judges, but we certainly could train them. And we could, because there is, as we've discussed during these weeks, there's lots of cross-pollination between the district court and the superior court and the probate court in terms of the cases that they do. So that would be a very easy fix, even if they were not part of the state system.
Thank you. Other comments? I'll speak into the void here. Judge Crockett, did you have something to add?
I had a question for Justice Gorman, and it's really as much to try to pick her brain. There's a lot to work with here. The chief judge component for a probate court, if the judicial branch or if the chief were able to choose from one of the 8 one of the 8 county judges, allow them to have some sort of relationship with a special, I don't care if it's an extra like $5,000 a year, so the chief gets a chance to choose. So even so it doesn't rotate, so there's some influence from the judicial branch for a certain term on one of those judges, because some of the judges may say, hey, I don't want to, but if the chief could reach out and designate someone amongst them, would that help? I know it's not a perfect solution, but how could we make it workable so there's a little more accountability? There's some teeth in it.
Well, I mean, as long as you have elected judges, they answer to the electorate. And so we don't answer to the electorate. And it's hard to imagine a system that would allow an appointed person like the Chief Justice to pretend to hold sway over someone who believes that she's been elected by her people to do X. I mean, it's a very difficult position for a judge to be in, I think, to be making campaign promises, and yet that's sort of what elections are all about. I know for the most part, Maine is has nonpartisan elections for judges, but I don't know if that's going to change. I think it would be a cleaner system if the probate judges themselves elected a chief from within their ranks. You could decide what the term is, and you could all swear a blood oath to follow what he or she says for that period of time. It would be a cleaner system. It certainly is not perfect. None of this is going to be perfect, but it would be, if you agree to be answerable to each other rather than to the Chief Justice of the judicial branch, I think it's a cleaner system.
Judge Libby?
I came here fully prepared to discuss, in all honesty and with an open mind, appointed judges. But I cannot say that I believe that elected judges cater to the people who elect them. And I know you didn't, maybe you did mean to imply that, because I realize that that is the currency of the land. I work so very hard to insulate myself from whatever the public wants to do. I feel that I am a judge, a real judge, and not just a judge who's elected. And as you all know, we don't even know who gives us campaign contributions. There are all sorts of very serious canons that control what we can or cannot do. Running for probate judge is a miserable thing. I know how to run for a legislative post, don't know how to run for a judge's post. You just try to do your job. And most people don't know what we do anyway. We're not high profile criminal things like Rittenhauer's case. We're just helping people with their wills and when their children need a caretaker. So I just want to set the record straight. I think these elected probate judges are extraordinary to a person, all 16 of them, and we do not make decisions based on pleasing our electorate. And I know you didn't mean to do that, but it really did trigger something that bothers me a great deal. I am president of the Probate Judges Assembly. Now, we may be in 16 different silos, but we sure have done everything we can to dynamite those walls down. We just spent 2 days in Tenants Harbor going over everything with the best of instruction from guardian ad litem training, the new statutes. We talk to each other. We have email chains. And yes, we are going to CLEs. We do all of those things. But I just cannot let this commission believe that because you're an elected judge, you're a lesser judge than an appointed judge. And I often wonder how people get appointed, if you want to know the truth. So I'm sorry, I didn't mean to be so emotional about it, but I just cannot let that stand unchallenged, that we cater to the people who elect us, because they don't know what we decide anyway about grandma's estate. Sorry.
Thank you very much. Go ahead, Representative Cardone, and then Justice Gorman.
But Judge Mitchell, I have to say your observations, and I don't believe that they are incorrect for the current probate judges, but they are exactly what concerns me. If we consolidate these part-time county positions into a full-time, higher paying, better paying, more, I want to say more powerful, but political position. I am concerned that these positions will become highly political. I think the district attorney's positions are way too political now, and I think DAs should be non-party, but they're not. And you know, if you live in a Republican district, you're going to get a Republican elected, even though or vice versa, Democratic district. It just, I really am concerned, and that is the main objection I have to going to Model B, if we call it that. I really am concerned that we are going to overly politicize these positions, and we're going to end up with bigger problems with elected judges than we currently have, which, as you have pointed out, maybe, may not be as bad as they could be. Or, yeah.
Go ahead and
Ju-
then we'll,
Just 2 sentences. I am not opposed to judges being appointed. I just wanted to say that. I just wanted to make sure you understood. I'm not opposed to that.
thank you. Justice Gorman, go ahead.
So first of all, Justice Mitchell, Justice Crockett, you both know that I think very highly of both of you and value your skills and think of you as colleagues, not as hacks. But what we've seen of the judicial elections around the country is, as Representative Cardone has pointed out, they can become politicized. I'm not suggesting that that has been the case in Maine. I am a little concerned that in the current world, it may become more politicized. But right now, we have 16 highly effective, efficient individuals who are serving the people of the state of Maine. So please, Libby, do not believe that I called you a hack or that I think you are a hack. You know that I don't.
I'd also like to speak up that my concern about, well, the appeal of Model B to me is that it seems like a much easier lift from an appropriations perspective. My concern about Model B is that it's not as ambitious as I would like us to be. I would like us to take on the concerns about adequacy of legal representation for indigent people in guardianship proceedings and other proceedings. I think that is from a kind of policy and moral perspective, a really important thing. And I would like us to be more ambitious and try to take that on. And I also do have concern about elected as opposed to appointed judges. I've just been the chair of judiciary for one session of the legislature. And I find that the vetting process is really helpful. And we do, as committee members, have a very thorough understanding of the skill set and qualifications of the nominees who we conduct hearings on. And I think that not with respect to any of the current probate judges who I agree with, I think very highly of, and I think are excellent, but that process, that vetting process that looks at qualifications vis-a-vis the subject matter in which the judge is going to be working, I think is really important. And I would like to see us, again, be more ambitious and to incorporate these 8 judges into the judicial branch as appointed judges. Yeah, I saw Justice Gorman's hand up first, and I would just encourage others to speak up on these important issues, the Model A versus Model B. Justice Gorman, go ahead, and then Judge Crockett.
Thank you, Senator Carney, but I had just neglected to take my hand down. I have nothing else to say.
Thanks. Judge Crockett, and then I'm going to ask others to speak up as well.
Thank you. And thank you for the kind words said by everybody. We should tell the county commissioners, maybe it'll increase the pay of the 16 judges. But anyway, the comments by Representative Cardone actually kind of hit a historical note, because her arguments were the same arguments made in the early 70s when they converted from a part-time county attorney to the current DA system. A lot of people thought it was a consolidation of power and that it was going to make it more political, because the old county attorney model, you could practice law and then be a prosecutor in the part-time, which is amazing. So they made the same arguments back then, but I think everybody today still concedes that the current DA model is far better than what the part-time county attorney model was. And there were some great county attorneys, and Severin Belleva was a county attorney here in Oxford County. Fantastic, right? And his brother was actually a probate judge at the same time. So there's some those arguments have been sort of made, but I think the same answer applies now. That it's a step forward. It's not perfect, but it's better than it was.
Thank you. Other comments? Go ahead, Register Ayers.
Because I'm in the trenches of the budget and the commissioners, I think this is the B is the path of less resistance. And I don't think anyone who's been in the legislative process knows that you can come in asking for a giraffe and come out with an elephant. I mean, you don't know. You don't want to, it's like buying a car or a house. You don't want to give the highest amount. You want to start out asking for the most you can get, and then you're going to get less anyway. You are when you come through the Judiciary Committee. So I would start out with saying, what's the price of the total takeover? What's the price of this? And go right down the list, because I just feel like, and anyone who's been in budget and been in county government knows that there's a fight all the time between the DA model and the commissioners. They groaned at the meeting when I said, it's going to be like, they could be like a DA model. I mean, there was a physical groan. So, I mean, I get what you're saying, but I don't think you should start out with the path of least resistance, because you're going to get resistance anyway. You might as well ask for what we really need.
Thank you. Others? Tudor Goldsmith?
Sorry for my slowness there. So, I mean, I think I'm inclined to agree with the perspective that it would be great to do a more wholesale integration into the judicial branch. But, just looking over the materials at how many times this has been attempted before and current budgetary constraints, I'm just concerned about how realistic it may or may not be. And so one thought that I had is that there could be something like Model B that's a little bit beefier. Maybe there's a way to have some oversight and to have appointment that still preserves this kind of county-based model. So, for example, it need not necessarily be appointment by the governor. Maybe there could be a procedure for some sort of a council that contained a county commissioner and some sort of other county-based official. I don't know enough about county workings to really say what would make sense, but it would at least take that fully elected piece off the table and allow for some sort of vetting to take place. I mean, when it comes down to it, even appointed judges are in a sense elected in that they are appointed by elected officials. So we're only one step removed in any case from election. And then in terms of the oversight piece, maybe there could be a state-based overseer of the system. And because the various county judges weren't actually elected, maybe they wouldn't feel quite so beholden to the electorate to the extent that's a thing. Maybe it's not. So maybe it takes that piece off the table. Just kind of spitballing.
Thank you. Other questions, comments, thoughts? Go ahead, Leo.
Well, this has been a very interesting discussion. And Kathy Ayers is a very smart lady. I think one of the things that she said is resonating with me, and that is that the model that we have, the Model A, is a real step forward. It is really consistent with what we've seen from all of the commissions, all of the papers that have been written since 1952. And it honors that work. there is, I think, certainly something to be said about trying to adjust the model a bit so that we avoid the perceived issue about control of county budgets. I'm not exactly sure how we do that, but it would require pretty specific details about actions that could affect county budgets and maybe the possibility of looking at those actions in another way. I don't know what the bottom line number is going to be, but you know, I know two things. We're never going to get the county commissioners to sign on to anything that this commission does. And I don't care whether it's plan A or plan B, there's still going to be that opposition. And number two, there's going to be a fiscal note, and it's either going to be a big one or a small one. And we'll have to deal with that in another forum. But I think that the purpose of this commission is to provide a plan for the legislature to determine. And I think we should give them the best thinking that we have and a plan that not only honors the work that's gone behind us, but brings us forward a reasonable step and doesn't settle for something that's really doesn't put us a whole lot ahead just because it might be easier to do.
Thank you. I'm not seeing any raised hands, but I would love for people to also share their thoughts on the two kind of big chunks of Model A, which is the one outlined in the document that was distributed earlier, and Model B is the proposal that Judge Crockett with some assistance from Justice Gorman has put together. But the two things that I'm concerned about, how important is it that the judges be appointed versus elected in your mind? And then secondly, how important is it to take this as an opportunity to provide more robust resources for guardians, ad litem attorneys, and visitors? So I would encourage folks to step up and volunteer their thoughts on those two things. Go ahead, Judge Crockett.
I just would like to respond to something Attorney Delicata mentioned and Register Heirs, which are both great points. To Attorney Delicata's thoughts, all those previous proposals, I'll point out, none of them took hold and none of them passed. That's one of the reasons why I'll call it Model B, or the Justice Gorman model, which would be aptly named. All great committees have a great name to go under. That's one point that I'd like to make, that history has proven that while it was all good work and everybody recognized the need for keeping and trying to do this appointed county piece, it's never actually worked. But nobody has come forward with no commission has come forward with a report that is as novel to say elect 8 district judges. Even the Futures Commission didn't go as far as to say elected. They went forward to say the districts. I think they said 5 or something like that, but they never went to the elected 8 districts. So that's why a new proposal seems justified. But the other point to Register Heirs' view was perhaps the commission report should lay out in tiers. This is option A. Option A is a complete integration, which we ballpark will cost about this much and everything goes. Option B may become the proposed model where you have appointed judges and keep the county system as it is and list out the issues and do a proposed budget, and do Model C and put the price tag on it and see where we go from there, as opposed to coming out with a recommendation that says $10 million, and that's the only recommendation, and then we become a footnote in history like a lot of those other reports were. That's the only reason I maybe we include more, because once that number comes out and one proposal is defeated, it doesn't necessarily morph. It's easy to kill something that way, but I just throw it out as a thought.
Thank you. And if we did, I mean, if the Judiciary Committee had 2 reports out, the OFPR would actually do a fiscal note on each of the reports. So I think that would be the 2 reports as opposed, or 2 competing models as opposed to a series of tiers might be a neater way to do it. Representative Cardone, go ahead.
To answer your the question that questions that Senator Carney posed, for me, it is very important that we do away with elected judges, that we have not only full-time, but that we have appointed judges, weighing all things in toto. And to me, it is also very important that the state take over the costs that we have been discussing for attorneys, guardians, visitors. To address Judge Crockett's thought about presenting several different models, I have no difficulty with that, actually. We could, because as a practical matter, I think that those things may get raised and proposed and fleshed out in the public hearing phase of this anyway. So I have no problem with saying, okay, we've looked at 2 or 3 different models and providing the details of them. I do think, though, if we did that, I would like some sort of vote on, X number of commission members support this model and Y number of commission members support this model. Even, I don't know whether we do that by name or just by number, but I think it would be helpful for the Judiciary Committee and anybody else who's considering this to know if it were an even split between 3 different models, or if there was one that was heavily preferred.
Thank you. Others who wish to comment on those 2 particular issues? I see Justice Gorman, your hand is up. Go ahead.
I want some clarification on what we can do. I mean, can we be so bold as to say there are 3 options and the legislature is going to have to choose among them? The first one is a wholesale transfer of the probate court with all of its assets and liabilities into the state court system and stripping away all of the county responsibility for those things, and then list what that includes. It includes figuring out how we can keep all of the wonderful registers in a way that makes sense within a state court union system, how we transfer elected judges into full-time positions. Do we need 16? Do we need 8? Do we need some number in between? And that's option A. Option B is the one we had been talking about, where it's, as I refer to it, the model that has a lot of complexity involved, because it involves now state judges working with county employees. And there's a third option, which is to continue the county model, but have fewer judges, have them full-time, have them continue to be elected. But there has to be an infusion of money into the county system and a requirement that the county systems actually fund the courts in a way that allows them to provide good and due process to the people who appear there. And if we can give that broad a response, I think that makes some sense. In the end, these are policy decisions that legislators are going to have to vote on, and they will have to withstand the slings and arrows of all the county commissioners who are not going to like any of these. But a lot of this has to do with money, and all of it has to do with politics. And I personally am not in a position to say what the political will is of the people of the state of Maine. But I also think that's not our job. I think our job is to say what the options are, to give sort of a rough outline of what the good points are and the problems are, and a rough estimate of the costs. And hope the legislature, in all of its wisdom, can figure it out. If we can do that, that would make a lot of sense, because we have spent a lot of time talking about the various options. I think everyone recognizes that the best thing would be to figure out a way to wholly move everything into the state system, but that is a fiscal note that will choke an elephant or a giraffe, depending on which one it is.
Thank you. I'll just comment on that. I think that you've really summarized the three options really well. My concern is I personally don't feel like there's a lot of support for option A, the wholesale incorporation, even though we all agree that that's the ideal. I guess that's another question to ask the group is are there people who would be who would want to make that as their primary recommendation? Go ahead, Representative Cardone.
I think the answer to that is no, but primarily because at least I am uncertain under option A, under the wholesale incorporation, what happens to the registry of probate. I don't quite understand, as Julie Howard pointed out to us in a previous session, we don't really have anything like that in the state system. So are we going to just absorb them into the clerk's office, or are they going to continue to operate as a separate registry? I mean, I think we'd have to be very explicit as to what we mean by that. And then depending on what that is, that's going to up the price tag. If we are talking about doing away with the registries of probate and just incorporating the whole thing, just incorporating everything into the clerk's office that is on the non-judicial side, I would not be in favor of option A. If option A meant we keep everything that we like about both systems, about everything, and it's just a question of how many millions of dollars that's going to cost, then I might say, yeah, but for the money, because I don't think it's going to pass. That's my problem with voting for it. So I guess I would need some clarification on what we meant by option A.
Go ahead, Judge Mitchell.
Just as there have been 50 years worth of studies about let's do something, and as Judge Crockett has pointed out, they came to naught, not for want of trying. The legislature has entertained bills, session after session, some to make judges full-time and not elected. And so I guess I see the role of this commission, and though I really appreciate Justice Gorman's outstanding summary of the three options, that it is incumbent upon us as a commission to make a recommendation. Pick one. Or if you want to, pick two, but at least give some guidance. That's the purpose. You didn't start this commission just to let us enjoy talking to one another around the horseshoe or on Zoom, but the legislature is seeking guidance from us. They, of course, are going to do exactly what they think is best, but this is an important piece of information. Everybody on here is knowledgeable. They have experience in district courts, in probate courts, legal services for the elderly, legislators. So we have something to offer, and that's what this resolve asked us to do. I must admit, when I testified on one of those bills, I said, go big or go home. But as I've thought more about that, I don't know how to go that big. I don't want to go home. I think we've come too far, and it would be wonderful if we could accomplish something that really moved us down the road. And if the bottom line for you, and I think that's a great question, is elected important? Because we did hear it is important to be full-time and not practice law, because that is an apparent or inherent conflict that no one can resolve. The question that wasn't totally resolved perhaps was elected versus non-elected. But I think this commission sort of pony up and send a strong message on one of these proposals. There can be minority reports, there always are, but I think you're the legislators, you tell me, aren't you looking for some guidance from all these folks before you deal? So that's what I would recommend, that we pick our poison and move on. But to do that, you've got to find out where we are. And then let's spend a lot of time if option A and B, I think A was the hybrid. A is the one you gave us to talk about.
So the numbers have changed, but originally
Okay.
Model A was the model that was outlined in the proposed model
Okay.
document that was distributed for today. And Model B was the model that Judge Crockett
Okay.
described.
So if those are the two with the most momentum, can we sort of focus on those and then decide and try to give you some guidance for when you come back in January, because you're not going to have a lot of time. We need to do the work, and I'm willing to do it, and you are too.
Yeah, and to your point, I think the more we can all agree on a recommendation, the more likely whatever we recommend is to pass, because the opinion and wisdom of all of us is what's going to carry the bill across the finish line. I know that Judge Crockett, you had been raising your hand, but I'd really like to get some other voices on the table, and we'll circle back to you. So for anybody who hasn't spoken yet, can you please comment on we've got several different matters before us. Representative Sheehan, go ahead.
Thanks, Madam Chair. I agree with Judge Mitchell. I think we need to be decisive in the guidance that we give to the legislature and also the Judiciary Committee. I would like to be able to work with something decisive and something ambitious, as Senator Carney said. I think we were charged with something more ambitious. I do think that seeing probate judges elected is important to me. It's a little uncomfortable when I describe to friends in other states the work that we're doing here and just how long it's been recommended that we move to full-time and also elected judges. And I would really love to see that through if possible. And as a member of Judiciary, not to put too fine a point on it, but if we're going to hear a lot of pushback in testimony, and if we're going to have to potentially kind of eviscerate our committee's recommendations, I'd like to start from a position of strength and ambition, and not something that's already somewhat compromised. And then to go back to your second question, Senator Carney, it does appear to be really important for the state to provide more robust resources in terms of funding for guardians ad litem and attorney fees and visitors. I think I covered everything.
Thank you. And thanks for volunteering to step up and articulate your position. Others who haven't had a chance to weigh in? Go ahead, Julie.
Thank you. And I'm sorry I haven't contributed much today, but I've been listening to the very thoughtful comments, and I really appreciate everybody's intelligence. Obviously, people care deeply about the situation. I actually live in New Hampshire, and I used to work in New Hampshire in one of the courts, and they have lifetime appointment. And I actually think that, just for what it's worth, I think that Maine has a great system of appointment with a review after 7 years. I think that's a nice hybrid model that I think is pretty effective, just again, for what it's worth. As an administrator in the courts, I can't imagine trying to administer a hybrid model like that. Just seems really, really difficult. I guess if there are only two models on the table, I vote for model 3, which is to take it. If we're gonna do it, we gotta just take it and put it in the judicial branch, because I think it's too hard to do it. And I think as much thought as we've put into this and the excellent analysis of the legislative staff, and I want to thank them for that, I just don't feel comfortable voting on either one. I hate to say it, but, and again, I defer to Justice Gorman because she's my boss. So whatever she wants is fine with me.
Can I ask a clarifying question? So when you say, I think you said Model 3, and I'm all confused with the numbers now, but are you saying the wholesale incorporation? Like
I know
bring
that's
the
not
entire system over to the judicial branch? Is that what
right.
you're
That's not
saying?
really on the table, but I think that's the cleanest, just from an administrative point of view.
What do you see as the major stumbling blocks of trying to administer a hybrid system?
Well, I think perhaps the county folks piece will want one thing, and the judge and whoever we lump in with the sort of the state supported piece, the potential for conflict there is really obvious to me. And so, I mean, it's very hard enough to administer a court just with one set of bosses and one set of, dictates, if you will. And I'm just very concerned. I can't really get into details about the back and forth, but I guess just budgetary, I think that's a huge problem. So I know that doesn't really answer your question, but I don't want to get into the weeds, and I don't think I really can.
No, that was helpful. Thank you very much. Other comments? I see. Go ahead, Judge Martin.
So I'm looking at the proposed models, and this, we've got A and B. The real difference between the two, as far as I'm concerned, is the either appointed or elected. I'm still hung up, Judge Crockett, and maybe you can help me with this, on the piece where you say if it's appointed, there's going to be this conflict between state and county. And I'm not sure what do you mean by that when you say that? I mean, are there instances that you've seen in other areas of the branches that exists, or is it something that we're speculating on and maybe something could come up?
Am I free to answer, Madam Chair?
Yes, you are.
Thank you.
Okay, well, I guess it goes to Ms. Howard's point as well, is that if you have a state judge and let's say the judicial branch takes over they appoint 8 judges, and that judge wants to have an additional hearing day in Piscataquis County, and the register doesn't want to schedule it. Who controls? The judge can't tell the register. One, they're elected. 2 is they can just say, you can have your hearing wherever you want to, Your Honor, as long as you find a courtroom somewhere, it's up to you. And you want to record it, you want to use our assets, you have no control. Right now, the probate judges, if a register went down, if there was an illness, and there's some counties that only have a couple of people in, register heirs can attest to this, that only have a couple of people in the probate office, okay? So the judge can actually go in and send notices. The judge can do informal estates. The judge can do all those things. The judge can direct the register, hey, I'm gonna have to have 4 days of court this year. Now, generally the registers, who not all of them are as great as registers heirs, but most of them are very good, and so we never get into any sort of conflict. There have been conflicts where registers have told judges, like Cumberland County had a great example 20 years ago, where there was an issue where the register wouldn't do certain things. And that was a problem, and the judge had to go around and to keep the court functioning. If register heirs wants to allude to that later, probably could, but that has actually happened where a judge has had to step in and do certain things. Pays had to be cut. Money had to be reallocated to a clerk in some courts that were doing more than what the register was doing because of the hours worked. That doesn't happen with a state judge. It can't happen because the county commissioners, you'd have to have the county commissioners would have to get your back on it as a judge. And then the flip side is which judge is in which court. You could have a different judge in Oxford County in 3 consecutive months, and the register could have to get relationships with 3 different judges, depending on what the proposal was. So that's one of it. But the other important point, and I think Ms. Howard alluded to it, was we're talking about this as Model A, the one with the appointed judges and elected registers. Now that I hope is not the end, because the people of Maine voted to integrate the whole probate system, to do away with county courts altogether. If I'm not voting for this in any way, especially if it says this is the end result, because the county courts were supposed to go away. That was what the amendment to the Constitution was. It was all going to be one judicial branch. Any step we take, Model A or Model B, is just an interim step to the eventual integration. I hope that's the desire of the commission. If it's not, then I guess I misread the room, that we were all, eventually everything was supposed to be integrated. So there's only one judicial branch in the state of Maine. And if I missed it, forgive me, but I thought that was what the goal was. And there's another point that was never answered at either previous committee hearings that now rears its head again. The Superior Court employees used to be county employees, and now they're state employees. So and they've been state employees for the last 40 years. How did that happen? We never got an answer to any of that, because Superior Court employees were not always state employees. Is that correct? Will some expert from the judicial branch tell me, or because eventually they figured out everything had to be integrated into the judicial branch. That was the ultimate goal. So I hope I captured everybody's thought right, or maybe I didn't.
Did you have any follow-up, Judge?
I guess
Martin?
I just, from just looking at both of them, I think like I said, the only, and I too enjoyed just to hear everyone out, just to see, because I mean, I have an idea and then I'm ready to go. And then I hear someone else say something, I'm thinking, oh, here we go. This is now I've got, but I'm concerned about what Representative Cardone said about the elections. That is concerning. We are in a different world today. That certainly could happen. And as it gets bigger, the job gets bigger, the danger gets bigger with elections. I just think that there's really not a difference between the two models, with the exception of appointed or elected. And I think if we are going to reach the goals that they've asked us to reach, the appointed model seems to be the more appropriate one to present to the legislature. That's my thought at this point. And that's my thought. Full disclosure, I'm not speaking on behalf of the judicial branch, as Justice Gorman said in the past. So
Thank you very much. And thanks for sharing your thoughts. And Justice Gorman, I think you've had your hand up for a little while. Go ahead.
Again, to borrow a phrase from Register Heirs, I'm going to talk about where the bear does its business. I'm going to get into the weeds a little bit about what the problems are. There is a turf war between county government and state government. Always has been, always will be. If we create a system where we have some of the people doing business in the probate court being state employees and some being county employees, we are not going to do away with the turf war. We're just going to bring it down to the blades of grass that those individual people have to cut. And we will not be improving the system, and we certainly won't be improving the system for the people who walk into probate court, because there will be internecine fighting, the likes of which we currently don't have, because the systems are separated. So I continue to believe that what we should do is transfer the entire probate court and its jurisdiction into the state court system. And that will take a long time. It will be a big process. It will cost a lot of money, but that's what should happen. If we can't do that, we can fix one current problem, and that is part-time judges. And if that's all we can do now, but there's a plan to fix the remaining problem, that we have a county-based judicial system that we no longer want to have, we come up with a 5-year plan for how to fix that and how to move it into the state system. That allows for a thoughtful process. It allows for stretching out the costs over a period of time. But I'll just suggest that the turf wars that currently exist. I mean, every year we have to renegotiate our leases with the county commissioners. It's a very, very, very uncomfortable situation. We've got the Chief Justice of the state of Maine talking to 3 or 4 individuals about how much we should pay to have someone clean judges' toilets. It's a mess. And all we'd be doing is making it worse and making more necessary and uncomfortable interactions between judges and county commissioners. And I'll just say that it's not something we want to replicate. It's not something we want to increase.
Thank you. That that level of detail was helpful. It paints a picture. What was Julie, can you comment on the 10?
Sorry, she gets a 10 from the Russian judge. So yeah, I like that.
Thank you.
That's right.
As you were speaking, Justice Gorman, I was reading the constitutional amendment, and it does say that the repeal of the county probate court provision in the Constitution, quote, shall become effective at such time as the legislature by proper enactment shall establish a different probate court system with full-time judges. And that kind of use of the word system, I mean, it's the system created by the constitutional provision will evaporate, and we will have to have a different system. So I think the 5-year plan is really important. I appreciate the way you phrased your point earlier. Representative Cardone?
Confused about which buttons to push here. I love the idea of a 5-year plan. The only problem with the 5-year plan is that it is recommendations at the most with how we get here, because as we're fond of saying in the legislature, one legislature can't bind another. So I can't say that if we get the fiscal note passed for phase 1 of this plan, that we are in 2 years going to get the fiscal note passed for phase 2 of this plan or phase 3 of this plan. I'd love to be able to do that. I am 100% in agreement with Judge Crockett that even if we got one model enacted, that I don't think that should be the end of the line. I'd love to get to the end of the line, which would be the full enactment of, the full incorporation of the probate system into the state court. But because of because we can't get a commitment beyond the existing legislature, I'm concerned that any 5-year plan or 10-year plan or however long plan we want to project be able to work, that we put together a model that's going to be able to work in all of its interim phases, just in case we can't get to 5 years, just in case there's a holdup and it's 8 years or 10 years or 20 years before we can implement something. Not that we stop working, but we can't just pass a 5-year plan in this legislature.
Go ahead, Leo.
Well, I think that the third paragraph of the first proposal that was handed out addresses that in a pretty concrete way. And it says the new probate court system will be thoroughly reviewed 3 years after it has been implemented. And then it says the review must include, and that section should be expanded. But I think that if we put in the legislation that we get a review in 3 years so that we can see how things are going and try to move ahead a bit more, I think that will be all we can do. And that doesn't mean that some other legislature between now and 3 years from now couldn't say, no, we're not doing that, and repeal that section if it was passed.
Judge Mitchell?
When I entered this process, as I said, I wanted to go big or go home. I have been through enough of the discussions and the research, and I've listened to all of you that I respect tremendously. I think that this commission has an opportunity and we shouldn't whiffle the ball. And I think that best opportunity, and I'm sorry to the administrators, I know it's hard, and I'm sorry about county commissioners because I love them dearly, but look, this model, the blue paper model, I'll call it that, I'll have it committed, that this model, which is called a hybrid model, makes sense, not just politically, but it makes sense because it works, because the standalone registers are fantastic servants of the people in our communities. And so that's why, as hard as it is, I believe that they should stay there. You can go down to your local courthouse, you can talk to Kathy Ayers or her team, and you can get dad's had no will, all these intestate informal procedures done. Why would we take that away? We haven't figured out how to put that in the district court yet anyway, and maybe we never will. So that's why, just from a policy perspective and what I think people would prefer who are on the receiving end of our judicial decision, it's okay, even if it's a challenge, to do a hybrid. So I don't know what we do from here. I guess you find out where everybody is and then we put the icing on the cake. But I have come down on this model that we've been talking about, which was the committee's model, because it really moves us forward. If you want to deal with elected judges, full-time judges, or getting rid of elected judges and making them full-time and making them part of the state judicial system, this does that. And so all those there are going to be barriers there, but we've never even talked about how you deal with those barriers. And I, for one, would like to have that discussion if it's possible, Madam Chair.
Yes, you may ask a question, and then Tudor Goldsmith will be next. Go
Okay,
ahead.
I guess I just wanted to ask Judge Mitchell, again, like I said, the difference between what you just said and what we've been looking at is either appoint or elect. What's your experience I guess the question I have, and this could be for Judge Crockett as well, again, I'm trying to kind of get a better understanding of how the dealings are between the commissioners and the probate court. Do you find that you have issues now with the commissioners, or do you work pretty well with the commissioners? I mean, in the general sense, do you see any issues at this point if they're elected and elected?
I can speak only for Kennebec.
Right.
And no, I do not have issues with the commissioners. Maybe it's because Kathy does such a good job at leading interference. She deals with them more directly than I do.
Do you feel there'd be issues if there was an appointed judge as opposed to a elected judge?
I
in
think
that
from the
same-
letter that the commission sent to us, they don't want us to change that. They
Okay.
want to leave the system alone. They believe it works perfectly fine as it is. I think that's what their letter said. So I would go by that only.
Thank you.
Tudor Goldsmith?
Thanks. So at our last meeting, there was a lot of discussion in favor of the hybrid model. And my recollection is that there were really two major points. One was concern that maintaining the county structure of the registries would ensure the same level of customer service throughout the state that we have now. And the second being that the idea of a wholesale shift to the judicial branch of both the judges and the registers would be so expensive that it would just never pass. And so for that reason, and for those reasons, I continue to think that the hybrid model is the best model that's been suggested. That being said, there do seem to be consistent concerns from both sides about the relationship between the state judges and the county registers. And one possible solution to that would be to try to cleave to some extent the relationship between the judges and the registers. I know they've had strong relationships to date. I think that's worked well to date, but under a different model, that doesn't have to be the case. And in fact, there are many things that the registers do that the judges don't touch. And there are certainly many things that the judges do that the registers don't have to touch. For example, scheduling could be done by somebody in the judicial branch as opposed to by the registers. And it could be the case that an informal probate just never crosses, never even comes into the judicial branch in a sense, unless there's some sort of an issue, or unless, of course, it turns formal by way of objection. So I think there are some ways to kind of tamp down the potential conflict between county and state and still use the hybrid model.
Thank you. Register Ayers?
Yeah. State and county, if you've worked for county as long as I have, there have been many conflicts, and the jail is number one. And right now, the commissioners are just signing on to a lawsuit to sue the Department of Corrections. So to say, I don't know how we're all going to sing kumbaya yet, but I really wanted to talk about the relationship between the judge and the registrar, because one of the registrars for a long time ago, Jerry Conley, he was a former politician who decided he wanted to be, he wanted to be a register of probate because it would be an easy job for him. And when he got there, he said, "Oh my God, I didn't realize how hard you guys have to work." And he was always impressed with that. But he used to call the registrar and the judge Adam and Eve of the Constitution. And so we have had registers and judges from different parties. We do right now. They have gotten along, and we have had absolute, what did you guys call it? Absolute turf wars, just horrible things that have happened. And it's personalities, and it's all personalities. But I don't know where I was going with this. I think when we were talking about a manual for registrars, I thought to myself, who's going to write the manual for registrars? I mean, seriously, there's not too many people in the whole state that know what we do or how we do it and how we do our scheduling. I would not like the state scheduling my courtroom, because the triage that goes on in the office, the triage of, I hate to say it, but is somebody going to die if this doesn't get looked at? Is that, it is that serious sometimes. Is someone going to, something bad going to happen? And, I have had a total great relationship with my current commissioners, and I certainly wouldn't want that to change. And I certainly have a good relationship and been blessed to have great judges. But yeah, separating us, I don't come to that lightly. I don't come to that lightly. And I don't even know which one of these two that I would really prefer, but you need to know the depth of the county and state relationship. It's nobody in county trusts the state, and nobody in the state trusts the county. And I don't know what you get. No model here is going to fix that. So I would say just, pick the best model that we have and go with it. I'm rambling now, so I'm going to stop talking.
Thank you. I didn't feel like you were rambling. I thought everything you said was really valuable. But that does remind me that we've been meeting for 2 hours. We're scheduled to continue to meet if we need to keep meeting till 5, and I'm guessing that we still have a lot to talk about. So let's take a bit of a little bit of a break. And if we can all come back at 2:40, does that work for everybody? That gives us a little bit shy of 10 minutes. Okay, great. So see you all at 2:40. Don't forget to turn off your camera and audio. Hi, everyone. I am sorry the break took longer than necessary or than we had originally intended. Representative Cardone and I met with our analysts and they reminded us that we have a report to write. And whoops, gotta turn on my camera here. We have a report to write and we have 2 more hours in today's meeting and then we have 1 more meeting. And so I have a proposal as to how we can proceed. And I would ask that I hope everybody agrees. And if you have strong objections, let me know. We are working now with 2 models. Model A, which is the proposed model that we have the sheet of paper that the analysts prepared for us, and there are a whole bunch of questions in it. And then we also have Model B, which we've talked about a lot today, and particularly Judge Crockett has been a proponent of Model B. And so what I would propose that we do is that we go through Model A and have Janet and Sam lead us through Model A because they have several questions that they would like us to weigh in on and that they actually need in order to write a report. And then Janet has some questions to ask with regard to Model B to fill in some blanks there. And then, and hopefully we'll be able to do that by 4 o'clock. I'm hoping. I will keep my fingers crossed and knock on wood and all that stuff. And then we will talk about what we want our report to look like at that point. Because depending on how those conversations go, people may feel one way or the other about the report. So this is about filling in some details in the report with regard to each of the model. And so is that okay with everybody? Hang in there and stay really focused on getting answers to the questions. Thank you. Okay, so I'm going to turn it over to you, Janet.
I'm going to attempt to share my screen. Okay, this was Model A in Senator Carney's recap. And this is based on what was written while people were speaking last time. But there were some questions built in when people were speaking last time. Those are the things I tried to capture in the red text with brackets. And then in addition to those things, there were some other issues that had been raised either in deeper dive questions or just in the discussion of that model generally that are all listed out. But within the first paragraph, which is written a little bit more report style-y than we wrote it last time, it just says create a probate court within the judicial branch as a state trial court distinct from the district court and superior court. And then with 8 in brackets, full-time appointed judges. And the 8 is in brackets because that was an assumed number based on the prosecutorial districts, but there was some question about whether it would be possible to pin that number down. So I'm just going to go with your permission straight to that first issue, because this was asked last time. Is 8 the appropriate number of new state probate court judges? If the commission doesn't believe it has sufficient information, because there was some discussion last time, what information would we need? How would we be able to calculate if 8 is exactly the right number? Do we have that information? We didn't have judge time from every judge, for example, who are probate judges, only from some of them. Could we figure it out based on the caseload data? Like, what would we do to figure that out? And when I say we, I mean you all, not me. So there are alternatives that the report could just say, recommending that the judiciary calculate the number of judges after gathering information that you identify as important to decide the number. Or you could just say 8 seems like a good number because of the prosecutorial districts and the current relationships with the counties already, and that would be fine. But that wasn't an issue you all identified, and we just wanted to point out you're not limited to just giving a specific number, because there will be more public hearings and chances to gather information when this goes before the Judiciary Committee. And there was some worry, I think, among some commission members last time that they didn't have enough information to agree to 8. So I don't know if you want to talk about that now or just continue.
Yeah, let's address each one as we go through. Catherine, go ahead.
So I think I was one of the people who had said that I just wanted to make sure that we had enough, because I think that there were some judges who talked about the fact that they kind of didn't report all of their time, or they might work more hours. So that would be important to me, that we would recommend that they look at the actual hours worked in each district. And I would say that from my perspective, it should be a minimum of one in each of these districts, but there might be a need for more than one in some of the districts.
Thank you. Other comments? Go ahead, Judge Mitchell.
I just have a question. I think that number is predicated basically on what they're going to be used for. And is the model contemplating they're still probate judges? But if they don't have enough work, they're going to be other jurisdictions like criminal law or backup family matters issues. What was the sense of the committee? Are they just probate judges, as we now know probate judges? Are they going to be used for other matters?
I think the hope is that we would stick the landing on choosing the right number, and that they would be almost primarily involved in probate court matters, but that if there were some extra time or resources, that they could be assigned to other matters in addition to probate. But we're hoping to really not expand. We're just hoping to be as accurate as possible.
It also was identified as an outstanding issue. It's number 10 on the document, because that was something that was raised last time. So it's definitely something that anyway you could address, but we have to address it if we go through this document.
Other reactions to the number 8? Go ahead, Justice Gorman.
So we chose 8 because it reflects the current number of judicial and DA districts in the state. But it occurs to me that I think if within this model, I think we should recommend 10. That will allow us to actually cover each district. It will also allow us to determine whether some of the current, I'll refer to them as probate cases that are being done by the district court judges, should be transferred back to these probate judges, so that there's more consistency in terms of how the cases are handled. And if we make it clear by putting into Title IV that these judges, to the extent that they have extra time, can be assigned to sit in the district or the superior court, will be doing good, not only for the people who need probate judges, but also those who need non-probate judges. So I'm going to propose that we increase it from 8 to 10. And one of those could become the chief judge of the probate court.
Great, thank you for that suggestion. How do commission members feel about the number 10? Is there anybody strongly concerned about it? Go ahead, Representative.
I was considering going to 9 because of wanting to name one of them a chief judge, or take on the duties of a chief judge. I mean, I guess it doesn't hurt to recommend 10. I think we're going to be hard stretched to get 10 funded. But I guess it doesn't hurt to recommend 10. I think we can justify 9. I don't know. I think if we really want to get 10 positions funded, we're going to have to work hard to justify that 10th position.
Would you object to using the number 10 and figuring that we might have to negotiate down?
I don't object to using, I mean, I suppose I don't object to using 15 if we want to. I just think we're going to have to work on the justification, but no, I don't object to 10.
Okay. Is anybody uncomfortable with 10? Go ahead.
I was looking for something and I can't find it, and that's probably because of me, but it's possible that it wasn't printed. Sam or Janet, somebody showed me a chart of the breakdown of cases in these judicial districts or the breakdown of something, and we were looking at the number of probate hours spent in these districts and what that would translate into a judge. Can you, that's what I was thinking of as I was rummaging through this. Can you point us to that?
We prepared it and showed it to you in response to your question, but we weren't formally asked to share it with everybody, but we brought it in case you raised that question. today.
Okay, I think I'd like you to formally, since we're on this discussion, I think that this is helpful. And yeah, that's what I was looking for.
Okay, so the question would be that we were asked is if the commission recommends the creation of 8 full-time probate court judge positions, would it make sense to assign one judge to each of the existing judicial regions? And the only information we had to use to break that down was the total probate caseload data from the ICON system with all of its potential flaws that have been identified. So if you look at the 2018 data, in 2018, there were 13,522 cases across the state listed separately in ICON. And that would average out, if you assume 8 judges, to about 1,690 cases per judge. If you then divide that into the regional caseload, and this is based on the court regions, which are also the prosecutorial districts, then you end up with these full-time equivalents, about 1 in York, about 1.5 in Cumberland County, which is region 2. Region 3 would have about 1, region 4 about 1, region 5 about 1, same with region 6. And then regions 7 and 8 have what amounts to a little more than 1, if I do my math correct quickly in my head. Then comparing that to the 2020 caseload data, which has different flaws in it because of COVID, you get very similar numbers. They're not identical, but again, about 1 for regions 1, 3, and 6, 1.25 for regions 4 and 5, 1.5 for region 2. And then if you add up 7 and 8, that's another full-time equivalent judge. But again, this is based on the assumption that 8 is the right number. This does not test the hypothesis of whether 8 is the right number. It assumes that. That's the inherent potential flaw or benefit, depends on how you look at it. It also assumes that the caseload data is an accurate way. And as Kathy Ayers so very adroitly pointed out earlier today, that caseload data includes things that judges don't touch at all, like informal proceedings. So it's just the data we had. So that's the data we used as just a rough rule of thumb way of dividing out where would the judges go if you had 8 judges. And so you could view it as 1 judge in each of regions 1 through 6 with another judge in regions 7 and 8, and then a last judge who could fill in the extra, overlapping above 1 full-time equivalent. That's one way to look at it. You could do it several ways, but to the extent this data helps, this is what that calculation yields.
I wanted to add, am I correct that we just divided it? Don't we have 9 prosecutorial districts now? Didn't we just divide Hancock and Washington?
No, that hasn't been implemented.
It hasn't been implemented.
Correct.
Okay. The only other thing about region 8, because when I looked at this, I originally thought maybe we could combine regions 7 and 8. But that's a lot of physical space to give to somebody. And I believe Janet looked this up. Aroostook County, this sounds like a John Martin amendment to me. If he's listening, I don't think he is, but by statute, the probate court in Aroostook County is obligated to sit in Caribou and Fort Kent. Is that the other place? There are 2 other places other than Holton that they're obligated to sit so many times. So that may actually be a bigger responsibility than it looks like on this breakdown here. So I think that's why I was coming out, based on seeing these figures, I was coming out with 8, possibly 9 that we could justify by putting in a chief judge, but I have no objection to more.
Thank you. Register Ayers?
Yeah, I just wanted to say a couple of things about that. The numbers that we used here, almost 8,000 of those cases are informal probates. So 7,897 of those were formal probate.
Okay.
Probate. And then the other thing, Region 8 is the seat is in Holton, and the registrar and the judge travel to Fort Kent, which is 50 minutes away from Holton, and Caribou, which is in a different direction, but it's 50. It's a 50-mile jaunt for them when they have court on those 3 separate places.
Thanks. That's super helpful. Go ahead, Judge Crockett.
I guess my question, this could maybe Register Heirs could straighten me out on it. Does this cover the open cases as well? The already continuing jurisdiction cases?
It does, because in those numbers, it has termination of guardianship, which also covers termination is now a modification, as well as termination and resignation. It's one petition. So it does, but it does not cover motions.
Or reviews?
Or reviews of the new reports, which are making contempt issues in our court. And they're also making contempt hearings as well as, review hearings if the judge wants to know what's going on.
So it sounds to me like, from what I'm hearing, is that there could be support for 8, 9, or 10, and that we will probably get some refinement on that as we go through the committee hearing and appropriations process. And so I'm going to suggest that we use the number 9 and include in the report that the number could be further vetted and refined in the committee hearing process. Does that sound okay to everybody?
Mhm.
All right, great. Okay. Back to you, Janet.
Just writing down what you said.
Yes, sorry about that.
Then the next question was, should each judge be assigned to one of the existing court regions or to other specified geographic regions? I'm not going to go back up to the text of the paragraph because that's the next part of the sentence. Or should the Chief Justice be authorized to make this determination? Those were the options discussed at the last meeting when this proposed model was put together. You could have a different option as well. I think this is why Representative Cardone originally asked us to put that FTE chart together.
Great, thank you. Does anybody have a recommendation on that point, whether we choose the existing DA districts or leave it to the discretion of the judicial branch? Go ahead, Representative.
Well, I don't know that I personally don't have a strong feeling on either one of these. I know from talking to then Chief Justice Softly when I was working on these issues in a prior legislature for a piece of legislation, that she wanted as much flexibility as possible. If she were asked her opinion, she wanted as much flexibility as possible in terms of assigning these judges. So I'm assuming from the judiciary standpoint, they would like that discretion to be left with the Chief Justice. We talked about actually specifically putting them into regions, primarily, I think, to placate the county commissioners by being able to say to them, look, you're going to have at least one judge covering this region. So you're going to get, for the money, you're going to get at least as much judge time, if not more, by having this proposal than just having your own part-time county judge. I guess I don't know how far that will go to placate them. I don't think we're ever going to get the county commissioners on our side 100%. Whether that is something that will help with the state county turf war, I don't know. So I'd be interested in hearing what other people have to say about that.
Go ahead, Leo.
I think that it will at least help with respect to legislators and their thinking about what their constituents need rather than any third-party interest. So I would agree with you.
Yeah, I think it also gives you a visual and makes it kind of more tangible. Justice Gorman, go ahead.
So Representative Cardone is absolutely correct. Former Chief Justice Softly wanted as much flexibility as she possibly could. But the problem with saying that these are not actually ascribable to a particular region is that if all of the people who apply to get this position live in York County, it's going to be very difficult for us to staff the probate courts up and down the state. And so I think actually ascribing them to a particular region makes a lot of sense, so that if a lawyer or a current sitting judge wants to apply for one of these, he or she knows that that's the Region 4 position, and he or she is expected to be servicing the courts in that region.
Thank you. Commission members, are we okay keeping in or adding the language each assigned to a specific geographic region? Janet?
So the only questions I have about that is the way this chart was set up, possibly not that helpfully, sorry, is the first questions are the ones that were actually raised during the drafting of those paragraphs. And then the other questions later are ones that we got out of the discussion. So 9 is not equivalent to the number of judicial regions. So we need to think about that. And then also whether you want to look at the FTE number at all, if it's at all useful to you, whether you need a full-time one in each of the upper counties or the down east county or the county.
I think you could say at least one judge is assigned to the specific regions of the existing court regions, but we could still have more than 8 judges.
Yes.
I think that would work.
That's a very elegant proposal. Everybody okay with that?
Mhm.
Okay.
Okay, then just to go back to the model. So we finished the first sentence. Then the next sentence is the new state probate judges will be supported by 2 law clerks. That seemed fairly firmly agreed to last time, but you can of course change that. And then it was not clear what the other judicial branch staff would be, but it was clear that some people felt strongly other judicial branch staff were in fact necessary. So to break that question down, we listed additional judicial branch staff. Would there be administrative assistants, judicial marshals, a facilities manager? That's somewhat related, not to the judges, but it is a potential other judicial branch staff. An IT staff person to help support their IT needs. And then would there be any new court clerk positions created? This was discussed at that time. It's really relevant to a different question, so we can come back to that part B later. But yes, it's about additional judicial branch staff, and maybe helpfully for you all, just focus on what do you need for those 9 judges. And then if there are other judicial branch staff, we can fill in other things here later.
Justice Gorman?
So going down the list that Janet helpfully created, I would say that we need 2 judicial administrative assistants, 8 marshals, 1 full-time facilities manager, and 1 full-time IT person. And the facilities manager is going to be more than full-time, as is the IT person, but those are minimums.
Commission members, are we, let's see. Do we want to specifically refer to the additional staff in this recommendation? Or indicate that new judicial branch staff who are expected to include enlisted? Go ahead, Barbara.
I see this as a political decision as to whether we include all of these folks now or not. I'm glad Justice Gorman has given us the the breakdown as she sees it. We don't have to include this, but I think ultimately when we come to public hearings and judiciary, and certainly when we come to any drafting of legislation, we would want to include this itemized list. And I think Justice Gorman, I'm assuming it would probably fall to Julie Finn or somebody in the AOC to say, we need these people because this is what they do. And if you've got 8 new people, you know, they need A, B, and C. There'll have to be some further explanation to go with them. I don't mean to burden you with that now, but whether we do that now or later, we're going to have to do it at an appropriate time.
Thanks. Register heirs?
I just had a question about a judicial administrative assistance and wondering about the integration with our staff, because we have, you know, there are counties that have judges already have a secretary. And like in my court, we have a different court clerk that sits on different cases, but I have a guardianship paralegal who does work. So, I mean, there are staff there that assist the judge, you know, so I'm just wanting to make sure that this is not going to cut into our staff.
Okay. Yeah, I think it's anticipated that it would not do so. Thank you. Judge Crockett?
To an earlier point, who's in charge of scheduling for the judge? Which one of these people? Is it still is it the registers, or is it well, now they're state court, so it's got to be the judicial branch since they're state court judges. So which one of these persons do that, I guess?
I am not sure that we're quite at the point of deciding at that granular level right now. That may be, Jen, is that a question that comes up?
That's a question in the next paragraph, which is about the role of the registers and do they maintain all of their functions, including that scheduling function.
Okay, so let's tackle this one thing and then we'll address your question in the next section, if you don't mind.
Okay, so it's not question 3 then, okay.
Catherine?
So is the next question 4 or is the next question 3B? Because I think that was one of the reasons that we talked about, would there be new clerk positions required? And I think that would be related to what the registers retain.
So
Okay.
this brings up,
Go ahead, Jen.
when Sam and I left the meeting last time, we left with a different understanding of what functions of the register would be retained, primarily because this question was raised, would there be more court clerks? So I left without understanding, Sam left with the other, and that's why this middle paragraph, it says what we ended up believing everybody agreed to was that the register would continue all of their existing duties. But we did note that we weren't exactly sure if this was the correct interpretation because of that question about would there be additional court clerks. That threw me for a loop and made me think maybe scheduling wasn't something the registers were still doing. So I'm not sure you all decided that. I was worried you had decided it and I was the only one confused. So I wrote it as if you had decided it because I had no faith in myself on that. But I am happy to be wrong about that. And that's why I asked the question, because that question about other court clerks totally threw me for a loop. So I think maybe as people are talking, really you hadn't agreed on that.
So I'm just going to follow up from my perspective. I think that where it came in my mind about the scheduling was more about, well, sometimes the probate court space would be used and sometimes it would be a state court space if that was available. And I think currently, Julie, you'll correct me obviously if I'm wrong, but that the clerks are responsible for making sure that there's space and how the courtrooms are used. So.
Do we need to get this granular?
That's exactly what I was thinking about, because I think that there will have to be a transition team that allocates specific job duties. And I don't feel like we're the right team to be doing that. I think it's probably sufficient to say that it is anticipated that new judicial branch staff will be required, likely to include and indicate the positions that Justice Gorman suggested. And then the report could also note that we will need a transition team to work out some of the granular detail, like where will specific functions such as scheduling hearings in courtrooms, how will that be handled? But I don't think that we can write job descriptions in the context of this commission meeting. Go ahead,
well,
Judge Crockett.
Yeah, so no, I completely understand about the detail piece, but I just want to make sure I understand this proposal correctly. Who is assigning judges to area? I mean, how much time they're sitting in their respective areas? Who's in charge of that? Is that AOC? Is there a special person? Are the counties, are the registers going to say, hey, I request a judge for so many days in my courtroom? Who's scheduling the judge time? I don't care about the courtrooms. I think that's too low level, but I do need to know who's in charge of actually scheduling judges per area or per county or courtroom rather.
Representative?
As I was envisioning it with a chief judge in place, that scheduling would fall to the chief judge of the probate court. I believe the chief judge of the district court and the chief judge of the superior court are in charge of the schedulings for their courts. Am I correct with that, Justice Gorman?
You
And
are.
Okay, so I was looking for that parallel to be put in place for the probate courts. If that's not what other people were thinking, then we should probably have a discussion. But that's what seemed to me to be reasonable.
If you want, we can skip to that question if that helps.
Sure, that's a good suggestion. Thanks, Janet.
So that's question 11. Should the state probate court have a chief judge?
Yes.
I think everybody's in agreement on that. So that was one done very quickly.
Should I write the part about scheduling each judge?
Janet, so I think if we're going to do a parallel, it's responsible for creating the statewide schedule. Because you'll remember that what they do is decide that Kennebec needs 37 days a month and, whatever else. So it won't be, they may not say every Wednesday has to be in Kennebec, but they'll say we need X number of days in Kennebec.
I vaguely remember this.
That's helpful language suggestion. Thank you, Justice Gorman.
So how does the register in Somerset County request additional court days? Do they have to go to the chief judge who says, hey, I want additional days for trial? Is that how the routing goes? If the register feels there's more time needed in certain trials, do they make the determination? Or how does a request for time in the respective counties work? How does it filter? What's the chain of custody here on a request like this?
Go ahead, Justice Gorman.
So what I would say, Jared, is if this is the model that is promulgated by the legislature, there will have to be a process by which the registers, the individual judges, and the chief judge meet twice a year and figure out what the schedule should be. And then that there's tinkering during the year, just as there is now. I mean, now Julie Howard will go to Judge Moskowitz or to one of the other judges in her region and say, we don't have enough family time. And those judges will contact their chief judges to get more time assigned to whatever docket is necessary. And I anticipate that as long as we don't have outright war between the registers and the state judicial branch, that kind of process can also work here.
Thank you. Is that satisfactory, Judge Crockett?
Well, the answer is satisfactory, although the implied resolution is ripe for problems. But I appreciate the input.
Register heirs?
Yeah, I just had a little issue with the paragraph in the document that talks about it talks like, or it sounds like we are just we're going to be left just doing the formals. But I just want to remind everybody, we have a full staff that is backing up our judges now. And I wouldn't want to lose that. And this is a kind of a kink thing for me in this model. So.
Yes, and I think the intent is not to reduce the existing staffing in the Register of Probate system. And I think that we can say that more in more detail if we need to. But let's keep going through these specific questions, because we do need to keep our eyes on the prize of completing our report. And Janet, I think are you ready to continue?
Believe so. So then state probate court proceedings will be held in existing county probate court courtrooms. And it seemed to be a consensus, although it wasn't entirely clear, that would be leased from the counties by the judicial branch. Some suggestions were made that wouldn't be necessary. I wasn't entirely clear on that. That's why it's in red.
Can I make a suggestion on that one?
So that's the next question.
Maybe like something about referring to with arrangements to be made between the counties and the judicial branch.
Yeah. Yes.
Because we don't know if there will be a lease or if there will be some other arrangement made. Is that okay with everybody?
Yeah, and I think that may depend on the individual counties as to whether or not they've got space in the courthouse. As I said, Penobscot County, the probate court is at a completely different building than the Registry of Probate, completely different building from the state courts. That may not be the case in several other places. So I think that's going to have to be dealt with on a more individual basis.
Thanks. And then Janet, whenever you're ready, we can. I know you're doing a gazillion things right now. Thank you.
Okay, I'll fix that later. Then, to the extent necessary in certain counties, state trial court courtrooms may be used to conduct state probate court proceedings. We did drop a note to this. This was said, and it was asked that it be written down. That seemed to us to be kind of like a granular thing as it's been described today. So we didn't know if you needed that sentence, but it's not our job to decide that, it's yours. And then emergency matters appearing on the state probate court docket will be prioritized and addressed expediently to the same extent that those matters are prioritized under the existing county probate court system.
All right, that's our first paragraph. Does anybody have questions or concerns that they want to go back to and address? No, okay. And then we're going to give Janet a moment to catch up with the decisions we've made, and then we'll go on to the next paragraph.
Okay, then the next paragraph was, and I hope that you will tell me how to fix the wording, because I didn't mean to give any impression that it wasn't going to preserve the register system, because that was made very clear last time. So to preserve the county register of probate system through which the elected county registers and their staff serve as county officers and employees, registers will retain their existing statutory duties and authorities, including but not limited to the roles in docketing and scheduling probate court proceedings, assisting parties in filling out probate court forms, and performing quasi-judicial functions in informal probate matters. Those were just the types of things talked about at the meeting, so those will be listed. And we didn't necessarily think you needed to list every duty here. We just did it to make sure everybody was on the same page that all of those duties, because like I said, Sam and I had a different interpretation of that conversation. So we just threw a couple examples out there to get you all thinking, did we all agree to that? That's the reason they're listed out. We don't need to list them out if it suggests they don't have any other duties. We mean all of the duties, because we think that's what you meant. if that makes sense.
It does. Thank you, Janet. And Register Heirs, can you weigh in on that language? And is there something that you feel we should incorporate in order to ensure that we are not shifting?
No, it does say scheduling probate proceedings and also all the existing statutory duties. So it does, it does say the right thing. It's just the conversation about scheduling confused me a little about that. So that's fine.
Mhm. And then I would also turn to members of the commission who are from the judicial branch and ask for if that language seems appropriate as well to you.
So can someone point me to the statute that defines the register's duties? And I don't want to get so granular in this that we're getting into a contest of language, but scheduling a hearing is one thing. Determining that hearings will only be held on Wednesdays is another. And so I want us to be able to, I want us to be pure of heart in what we're talking about here.
Sure. The duties are starting at 1501 and go to 1506. But I think that we're not going astray. I mean, the on Wednesdays is the 1 day a week issue. Is if they're full time, I don't think that's really going to matter. They are generally set by that judicial calendar, and most of them are, the return days are on Wednesday. Ours used to be Monday, but when a new judge came along, she thought Wednesdays would be better. So that's went to Wednesday. So I don't see that. I don't really see that as an issue. I mean,
Justice Gorman, I do want to point out that at the last meeting, a document was handed out. It does provide a list. We did look through the statute. This is like micro type, so I don't expect you to be able to read it here.
Okay, great. Thank you.
These are the things we found. I don't know that I saw scheduling in the statute. That may have just been understood. I would have to reread it, but if you look at the November 1st meeting materials, probate court jurisdiction and register duties, those were the ones we found, and there may be more that we missed, but those were where we listed them.
Okay, so to Judge Crockett's questions, can we take, and I guess I'll ask Kathy if this is okay with her, can we take scheduling out so that there's no perceived problem between the establishment of a court's schedule and the determination of what goes on that schedule? Is that, do you think that's stepped over the line, Kathy?
well, I mean, I just think that I do all this. Let's listen. I'm gonna just make it personal here. I do all the scheduling, but it's always in conference or in conjunction with what the judge thinks is the higher priority. So, I mean, if something comes up and she thinks it's a big priority, then we get it scheduled. But it's so different now because they have to make time. You know what I mean? They have to make time to come and see us. But if they're going to have regular court days in more than one day a week, I don't see that as a problem. I'm afraid to take that out of there because Chris Berry said it. I mean, we do a good job of the scheduling. You can call us up and we will get you in if it's an emergency. And I said the same thing on the hospital committee with their emergencies that I'm on. You call us and we get it. If there was, I don't know how we would word that. Maybe the wordsmiths.
I think Judge Mitchell may have an effort at wordsmithing.
This may be too simple, but I'm thinking that the scheduling could be the state courts in conjunction with the state registers because they need to talk to each other.
Yeah,
So just
yeah.
those words might alleviate Kathy's concern and accomplish the goal of Justice Gorman. I don't know.
Yes, go ahead.
Are we talking about two different schedulings though? Justice Gorman, when you say a state, if the state schedule made the schedule, the chief judge made the schedule, aren't we just talking about a docket day, like a particular need for certain cases? And then it goes to that schedule goes to the registrar, and then the registrar actually schedules individual cases. Those are two different scheduling purposes, right?
Well, right, and that's what I'm trying to speak to. There's
Okay.
the creation of a schedule, which may have 5 days are necessary in Kennebec County.
Right.
And then there's the figuring out of when those 5 days occur and what happens on those 5 days. But even within the judicial branch, we have had some clashes when clerks have scheduled days in court that we could not cover with judges. And so I'm being mindful of the idea that we have limited resources in both systems. And I don't want this to be used as a cudgel.
Is the in conjunction with language
That's fine.
acceptable all around?
Yes, that's fine with
Okay.
me.
That's fine, but it does really bring up the part about emergencies and how that's going to be handled, but we can skip forward.
Yeah, and we do the section that talks about the probate judges does talk about emergency matters being scheduled to the same extent that they are now. So that is preserved.
Beautiful.
Okay. So
So
let's see.
I
Janet, go ahead.
I would stick maybe it up here next to those emergency matters, since that's kind of about scheduling. That the scheduling we conducted in cooperation, I hate to say this now, but I'm not sure who in the judicial branch it's in cooperation with, because there was that question about court clerks. So I'm not sure if we're saying the judicial branch cooperation is only in setting the number of days, and then all of the docketing in the actual case assigning is still register specific, in which case I would put this language somewhere else, but.
Could we say that the registers will work with the judges to establish the schedule? Because that does involve both systems.
That seems great.
Yeah.
Which is what happens now, and we anticipate will happen in the future.
So which judges, the chief judge or the individual judge assigned by the chief judge to the
Both.
respective area?
Both.
So we got the register, the chief judge, county commission. Okay. Okay.
So that was my solution that's highlighted now.
So the gray highlighting,
Correct.
okay, is that okay with everybody? I'm
Okay.
hearing some mhm. Okay,
So then the next sentence was state probate court matters will continue to be entered in the Icon electric case management system. And then there was a discussion about a possible long-term goal, seeing as you use the word possible, that makes it red in this document. So the possible long-term goal of developing compatibility between the state probate court case management system and the case management system employed by the other courts within the judicial branch.
I have a suggestion for how to deal with that. Perhaps we could say that it will initially continue to be entered in the incon, and then the red type, which is more of a transitional thing, could be added to the subject matter of the 3-year review. How does that sit with people? Does anybody object?
No.
Okay, great.
And that's actually how question 5 is worded. So I'm gonna.
So we're, Judge Crockett, your hand is up and I just wanted to know if you had another question? No, okay, thanks.
Something was deleted before it was printed, so I just filled it in, sorry. So we'll leave it at that. They'll initially continue to be entered in the Icon case management system, and then to increase uniformity across the state, the main rules of probate procedures. I added a little detail here about how this could happen. What you all said was the main advisory committee on probate rules would adopt and update as necessary a manual for use by the county registers in processing probate court matters. But as far as I can tell, that committee exists as a creature of the rules of probate procedure. So that's how I wrote it, is that the rules of probate procedure would have to be amended. And I was thinking of this as being a recommendation in your report. So you'd have to recommend that that change be made because the legislature can't make that change. Does that make sense?
It does. Comments on that, Register Ayers?
Yeah, no offense to the state judicial before I start, but the main rules of probate, the Supreme Court committee has just been spent a lot of time, and I spent a lot of time this summer looking at the rules regarding the electronic system. And I think there needs to be voting members of the registrars on this committee. This has nothing to do with what we're doing now, but I really, and I don't, you give them too much to do and they are no longer volunteers. You know what I mean? We lose people because I feel sorry for Miles Hunt, how much work he's had to done and the people on that committee. I really do, because the forms, the new code, the rules overlap the statute, and to try to figure out, you know, what you're supposed to do takes a Harvard lawyer, or maybe even a Yale lawyer. I'll be nice. But yeah, I don't, they don't understand our side of what we do. They don't see our computer system. They don't, you know.
Okay, yeah.
Yeah, I just think there needs to be voting members on it, and the rules exhaust me. So yeah, that's
Okay. Let's figure out how to fix that. Tudor Goldsmith, go ahead.
I'd just like to agree with Registrar Ayers. I'm on that committee and I wouldn't have the first idea how to draft a manual for the registers. And it is true that particularly Miles is extremely busy with that committee, with all the new forms, the new probate code. That's not to say that there couldn't be a role for the committee in it, but it would require a ton of input from the registers. And I don't think it's fair to the couple of registers that are on that committee to rely on them exclusively to basically take on this task. And I think that's functionally what would happen.
Thank you. Justice Gorman?
So I think now that we've agreed that there will be a chief judge of the probate court, it would be great to also identify sort of the chief register, maybe, or a council of registers, and then task the council of registers with these kinds of consistency jobs. I mean, if Registrar Ayers would like to be an immediate and permanent member of the Committee on Probate Rules, I'll speak with Justice Connors this afternoon and make it happen. But I don't think we need to go through the Rules Committee now if we create systems within the probate court to do it on their own. So although I think this was my recommendation to begin with, I think I would take it away from the Probate Rules Committee and put it into a council of registers, because as we all know, they actually know what should be in the manual, and we don't.
Go ahead, Representative Pardo.
Yeah, I agree 100% that it ought to be the probate registers that write the manual. Can we, if we are leaving them as county elected officials, can we create some sort of council of probate registers? That would be my only question about the suggestion. We now have these elected officials. Can can we give them another duty?
We're a statutory court. So you make it statute and you're telling us what to do. So I don't think we'll have a problem with that. But I just want to say about putting me on that committee right away. I am not the smartest registrar. I certainly am not. And Sharon Peavy from Waldo and Carol Lovejoy from York, they are my brain trust. And they're the ones that usually are number one on that. So I just wanted to say that.
Go ahead.
I'm not sure what we're envisioning for a manual. I know there was a manual on probate that my husband authored. That's probably not the level you're talking about, but he was paid to do that. And are we expecting these people who are overworked as it is to craft such a manual? Is there help from the university, or is there some other place we could get some help? Writing a manual is not easy. And you're asking them to do that in addition to all they do. So I'm just wondering if we could be a little more creative with how we get that done.
Yeah, so Representative Cardin, you said, or is it, what do you mean by, is it a subject of statute?
I said, or is it a subject of statute? Is it something? I know we wanted to put this in here because we wanted to put something in this report or in the statute about helping probate registers, helping to create more uniformity in the probate courts, especially at the informal probate level. But I'm just wondering whether it's an appropriate provision to put in a statute, or whether I'm thinking whether the Registers of Probate Association could, find some money with a private grant to help them write something and promulgate it. I don't know. I'm just grasping at straws here. But I don't want to get too hung up on this, this particular provision.
I think the observation earlier about if there is a chief judge of the probate court, making the chief judge the convener. Justice Gorman and Register Ayers, did you want to weigh in on that?
So I think we should take out this sentence. And then if this moves forward, one of the first things the chief judge will want to do is meet with the registers and find out what they need to help them move forward with their current jobs, and also to help train anyone new coming through. But I don't think we need to micromanage that at this point.
And I think that just having the goal the goal is uniformity, not a manual. It's uniformity, and it is help. So yeah, I think that if you have a chief judge, we'll be able to get that done.
Do we need to include some reference to the chief judge collaborating with the registers to assist in establishing uniformity? Do we need to mention that at all? I guess is my question.
Well, I think to the extent that we're actually talking about, and I don't think that was part of this original draft, when we talk about the job of the chief judge, among that person's duties would be to move the probate court forward with regard to consistency across the regions.
That seems like a great way to deal with it.
Yes.
Great. Thanks, everyone. So we're going to take out that last sentence of the second paragraph and instead address that topic in the context of the responsibilities of the chief judge of the probate court.
Okay, I will add that to the paragraph above, which is about the judges, but I'm not going to make you watch me try and figure out the words now, because you'll be disappointed how long it takes me to write a sentence.
Thank you, Janet.
So then the next paragraph was that the new probate court system would be thoroughly reviewed 3 years after it has been implemented by, and then it's not clear who it's going to be reviewed by. The review must include, at a minimum, there were only two things mentioned specifically in the last meeting. An evaluation of whether the number of supported state probate judge positions is appropriate and whether any additional steps should be taken to enhance the compatibility of the state probate court system with the other courts within the judicial branch. So it was hard to really rearrange the way that was written last time. So I thought it better to ask questions. So first of all, do you have any recommendations regarding who is on this 3-year review commission? And then what specific items should that 3-year evaluation address? You already mentioned the long-term goal of the compatibility of the case management systems.
I have a suggestion for the first the legislation creating a new commission. Can we state that the judicial branch will initiate legislation launching a review 3 years after implementation? Do you think that that would work, Justice Gorman?
Well, in the same way that I understand that you don't want to tie the hands of your successors in the legislature, I would be loath to tie the hands of my Chief Justice to have to be the person to lead this review. I mean, this is a legislative action. So I think that actually this commission or some iteration of this commission should do the review.
Yeah, I agree with that. It's the question of who is going to introduce legislation. So the judicial branch could offer a bill that would create a commission to do the review, or the chair of the Judiciary Committee could, but you think it should be the chair of the Judiciary Committee? Okay.
You can do that, or you can actually put it in this bill.
You can actually say that the commission will be created?
You can create it by statute.
Okay, then
And
I
it
think
can
we
be a
should just,
statute with a sunset if you only want it once. It might be unallocated provision depending on how the revisor's office uses the appropriate way to do that, if it's only going to be a one-time thing. But it can be part of the legislation. It doesn't have to be. You can say separately that there'll be a new.
let's make it part of the legislation. I think that that's by far the easiest way to do it.
Okay.
Thank you. For some reason, I didn't realize it could be done that way. Thanks. Register heirs?
Aren't you glad that they didn't hurt my vocal cords?
We're so happy that you're here.
So I just wanted, if we do a review and keeping in mind that I have dealt with this subject every 2 to 4 years for the last 28 years, I would like to see that the information that you're going to ask of the probate courts be standardized. That, we've got you caseloads, we got that. But there are other things, and I know that Leo asked for some things that we really couldn't answer or delve into because we didn't have the right proceeding codes to count certain things. And so just parameters for the report when it comes. And I'm not sure that has to be in here, but I would like to see that happen. I think the probate courts should report to the judiciary, just like the judiciary courts do every year, with the caseloads and the information and the budgetary information from the counties. I think that maybe that should be written in statute so that we don't have to do this scramble every time we need something or every time something goes awry. So that's my 2 cents.
Thank you. I think with regard to the 3-year review, it's not contemplating a specific report, but I do note and appreciate your suggestion about having the newly configured probate court report annually to the Judiciary Committee. I think that's a great suggestion. Let's pause for 1 second and see. How are we doing, Janet?
How am I? I'm fine, whatever you want to do. I was just wondering if that would be a chief judge job, that's actually a question for Justice Gorman. I know that those annual reports are done now. I can't remember if it's by the chief judge and if we could tack that on to that sentence that I haven't yet written about the chief judge, if that helps.
Yeah, I mean, I think that among the jobs of the chief judge is to come up with an annual report as to how the court is doing. Excuse me.
Great. That's a good way to address that. Register Ayers, did you have your hand is up and I didn't know if it was residual or with a new comment? Great, okay. Other suggestions for what the 3-year review would include, and I would like to include review to determine whether any jurisdictional changes in the probate court are needed.
Can I back up? Did we agree if the commission would have the same statutory composition, so it would have a member of the ABA, just like the 15 positions spelled out in the original?
Yeah, is that okay with everybody? It would be the same description as this commission. Okay. Looks like it's agreeable to everybody. Thank you, Janet. Go ahead, Barbara.
I don't know quite how to say this because I don't want it to be off-putting to anybody, but I would like the commission to look at whether there need to be any further alterations in the way that in the statutory scheme that we've got here. In other words, do we want to at some point be prepared to go in and say the registries of probate are all going to now be state employees and state funded, and we're going to have to figure out how to do that. I mean, I think we at least want to look at that. I'm not saying we make them go away, but I think that as we were all talking about the ultimate goal being this whole system be incorporated into the state judiciary, we got to figure out the next step, and somebody's going to have to look at those next steps.
That's what the compared to item 15 below means. So if you look, I didn't feel like people had specifically said it, so I didn't feel like I could put it in the top column, which was questions specifically raised, but it was discussed that as an alternative to the big goal that people have said of moving everything wholesale would be to do this 3 review and then maybe either in the report itself create the phases and lay them out, which was the proposal. So that's what question 15 said, is should you actually lay out in your report that you make the phased in approach, or should you direct the 3-year review committee to do that, was the alternative. And I didn't know where it belonged, so I kind of stuck it over here as another question.
My gut reaction, although I'm amenable to change, is that we don't know what's going to happen in 3 years. Especially, we don't know what's going to happen in 3 years with funding and revenues. So to say now in 3 years or in 5 years, we're going to fully fund under the state from the general fund all of the state registry of probate positions and lease all that space and everything else, I think is going to be a big problem. I think that the commission's going to have to look at what's doable in 3 years because there might be something more urgent because we might not have the revenues, you know, for all those reasons. Now, if somebody thinks, well, no, we should be more concrete about it, but knowing that that it might not come to fruition, I'd be willing to listen to that too. But that's my thought.
Any agree? Let's see. Let's ask if there are disagreements. I am not seeing any hands up, so now I'll ask the flip side of the coin. Is everybody generally in agreement with that approach? It looks like Judge Crockett is indicating.
Yeah, I don't want any of my silence to be mischaracterized as agreeing with I've got several issues with this that I've already pointed out, but I don't want to be mischaracterized as going along and doing the groupthink thing. So I just want to be clear. I don't agree with it. I see a huge issue with the state courts using county employees, the rules manual, the unfunded portion, the routing of scheduling, the time. I mean, there's a lot of issues that have been raised, but I don't want to destroy the committee's time. So I've been
Yep.
quiet.
No, that's helpful to just to note that, and we appreciate that. And, you know, we will be voting on the report, and people will take the votes that are truest to how they feel. Thank you.
So would it be fair for me to work on wordsmithing this later, not now, wasting your time, but that the review is going to include an evaluation of how to achieve the ultimate goal and how and whether to take the next steps for achieving the ultimate goal? I'm not sure I really understood. Is that what you meant, Representative Cardone?
Yeah, I'm not clear on wordsmithing it right now either, but I think when we started this discussion, we were all in agreement that the ultimate goal was eventually the whole thing comes into under the state judicial system. And I just don't want to lose track of that ultimate goal. I want it somehow to be reflected in what the 3-year evaluation does. I'm not saying it's going to be ready in 3 years for everything to happen, but I don't want to lose track of that ultimate goal.
Yeah, I would be more comfortable with language that talks about moving toward the ultimate goal rather than actually coming up with a plan to achieve that goal, because we don't know. There's so many unknowns at this point.
Okay, so we'll work on that wordsmithing later. So then there were other issues that you may or may not want to address either now or ever, or you may want, I mean, seriously, you may not want to, or you may want to highlight them in the report as issues Judiciary Committee should raise or not. These were just some we pulled out of the deeper dive and other discussions that happened.
On the fees, because I think we did want to address who keeps the fees. The probate court fees are standard statewide, correct? Kat,
Yeah, I mean, they're set by statute or court rule, but we do have a few fees that are not set by statute or rule, and they're like publications. We have to go through the commissioners to make sure that we're not losing money on our publications, or a notary fee that was not in it by rule or by statute that we have, or processing service fees. When we do service, they can be different. They have been traditional.
because the sheriffs may be different. Yeah.
Yeah.
But is there any reason, if we were to adopt the model that we're working on now, is there any reason we would have to change who sets the fees for the court?
No, I don't think so, because they're set by statute and they are set by court rule. And if the district court has a court rule that sets a fee, we can use it. We can use what they set. So,
Okay.
And that's in the statute.
And similarly, I personally don't think we need to change. I mean, the fees currently go to the county probate courts. That's correct?
No, they go to the general fund. They go to the general.
Of the county general fund.
Yeah, they go to the county general fund, and they do not cover the cost of the court, but they do help.
Okay. So it seems to me like that's something that at this point we don't need to change.
I would leave those fees with the counties at this point to help defray the costs that we're still asking them to pick up. And I think that's going to be.
Is everybody comfortable with that decision?
Yeah.
Yeah, looks like it. Great. Okay.
Then we have the larger money item, which is how will the following be selected? Who will pay their fees and what rates should be paid? And that's for court-appointed attorneys, the guardians ad litem, and court-appointed visitors.
Representative Cardone, I feel like this is your,
Sorry,
we're at item 9.
oh, I'm sorry, I was looking at item 13 here and, okay. My recommendation is that on item 9, that court-appointed attorneys be paid by the state through MCILS. And court-appointed guardians ad litem and visitors be paid through the state as they are, well, I know we don't have visitors, but essentially the state court picks up those costs. And I don't know how the budgets are broken down, but in the same way that a district court judge would appoint a guardian ad litem in a Title 22 case, I would see a probate court judge appointing a guardian ad litem and that money being funneled that way.
Did you, Judge Martin, did you want to weigh in on that?
I agree. It's consistent with what we're doing now. There's no reason to change, make it different. So I think that's appropriate.
Anybody have a differing opinion on that?
Not a differing opinion, but I do think you need to put for indigent there.
Thank you. Any other thoughts to take into account on this topic? Thanks, everyone.
Then another question that had been raised was whether these 9 now state probate court judges could be cross-assigned to preside over district or superior court dockets.
And I think that we've got Tudor Goldsmith and Justice Gorman. Why don't you each weigh in?
Tudor, go ahead.
Thanks. Yeah, I know this isn't everybody's opinion, but my perspective is that we should not be cross-assigning judges. One of the major concerns that's been identified by a lot of attorneys who practice in probate court is that there is the speed with which things get decided. And I think there's a concern that if probate judges are also available to hear other types of cases, that those other types of cases in many instances will have priority. If there's a criminal matter that's going on, if there's, things that might actually be more fundamental rights, those types of things are going to take priority. So, I mean, maybe that's what is in the better public policy. I don't know, but I would say that from the perspective of trying to retain features of the current probate court that seem to be working, having judges have to kind of split their energies could end up resulting in additional delay.
Thank you. And Justice Gorman?
So let me propose a little bit of a compromise here. I think for the first 3 years, there should not be cross assignment because we actually need to be gathering data on how busy these judges are, how effective these judges are, and we can reassess the need for cross assignment after we have more information on how it's working.
How do commission members feel about that? Judge Martin's in agreement.
I'm in agreement. I was all ready to say, of course, let's do cross assignment, but Justice Gorman makes a good point about being able to gather pure information here. And if we have all sorts of cross assignments going on, we're not going to have a good read on what the docket requirements or what the judge hour requirements really are.
Good point. And Judge Mitchell?
I fully support no cross assignment for the first 3 years. We've got to get our feet on the ground, put it in the reevaluation in 3 years.
Yeah.
Okay. Sounds like everybody is appreciative of that suggestion and that we're all in agreement. Great, okay.
I think I captured that. And I put some things in parentheses so we would know how to write that in the report. So I know it looks a little messy. We already talked about the chief judge, which so far I've written down for creating the statewide schedule, doing the annual reports and uniformity. That's funky language, but it will be fixed. Then there were questions about whether recommendations should be made for other facility issues. There were 2 examples given last time. Entry screening, should that be conducted for probate courts and or the registries? And the accessibility potential issues of state and probate courtrooms and registries were 2 things that were mentioned, for example, at the last meeting.
I feel like I'm making the chief probate judge's job a really big job, but I kind of think that that should be one of the assignments for the chief probate judge. But I spoke before I noticed that Justice Gorman's hand was up. And she knows a lot more about these issues than I do. Go ahead.
I agree. I mean, if this goes through, the chief judge of the probate court is going to have to figure out a lot of day-to-day issues, including whether, well, just a lot of day-to-day issues. And I don't think we should try to pre-decide those now.
Yes, go ahead.
I agree with the chief judge taking that on, but I also want to raise a question. My court has no screening at all.
Mhm.
And so the chief judge says, well, that's not right. This is a very volatile court with people who are very unhappy often with decisions. Do you need security? Who pays? How do we deal with those issues? I mean, we don't have to answer this in the report, but I think we have to think about it and be aware of what we can ask a chief judge to do when we've got this hybrid model. That's all.
Mhm. Yeah,
And-
and we did, I mean, one of the additional staff that we identified was at least one marshal for each judge.
Yes.
And it is a little more granular than this report, but I think we said it's anticipated that it would include 8 marshals.
Should that say 9 now?
Pardon me?
Should that say 9 now?
I don't think so, because I think we contemplated that there were going to be 8 districts
That was just,
and then the chief, but I'm open to
I just want to make sure I hadn't
feedback on that.
messed it
Yeah.
up.
Okay. Go ahead.
Libby, you're saying you don't have screening now,
Absolutely correct.
but don't people coming into your courtroom get screened through that main entrance to the state? No, you have a separate entrance?
We have an entry, the district attorney has an entry, but we don't have a marshal there or anybody to screen. Well, they have I think a machine.
Uh-huh.
Kathy can tell you what the DAs, but we have nothing. We have a door that says probate court. You have to wear a mask. Come on in. Go in the courtroom until you're invited. Sit on the bench. But that's what it does.
Okay, but that's a door coming in from the outside?
Yes.
All right, I'm sorry. I thought everybody who went into that whole complex went in through the judicial, the main entrance. I suspect that ultimately we're going to try to be looking at having entry screening at any place where the state is holding court on a regular basis. But this is going to be a county to county difference. Some probate courtrooms are in the same complex that the state uses and are going to already benefit from that state screening. Others, like Kennebec County and Penobscot County, are not are not encompassed by that. So we may have to look at additional screening points to be added. But as Justice Gorman pointed out, we've got this last state budget created 10 new judicial marshal positions. And we're looking to create 10 more in the supplemental coming up, so that at the time, not counting anything that we're doing here, 20 new marshal positions would have meant universal coverage for the state judiciary in these entry screenings, but we can't even find people to fill those first 10 positions. I think Justice Gorman said those positions still remain unfilled. So this is a workforce problem as well to have to deal with.
All right, so we have a question to answer related to Janet, what question are we on again? I took my glasses off. Okay, entry screening number 12.
So it's whether there would be recommendations for facility issues. So you could just not make a recommendation. You could just say, we know these may be issues in the future. You could recommend that the chief judge, to the extent possible within existing resources or the resources created by this bill, address these issues, or make recommendations about further budget requests or things like that. It's really up to you how you want to talk about it or whether you want to talk about it. Just because it was mentioned doesn't mean you need to put it in the report.
Yeah,
Thank you.
I think we should look at recommendations from the judicial branch on this. I mean, I think this is something that might have to come from the Chief Justice. Yeah, we need, 4 more entry screenings statewide or whatever it is.
Do you want to suggest some wordsmithing on that one?
So could we simply say that the chief of the probate court will work with the SJC to ensure the safety of all members of the public and staff of the probate courts, the safety of all members of the public and the probate courts?
Thank you. My wordsmithing skills decrease with the sun. That's much better than what I could have done at this time of day.
I would also like to incorporate language pertaining to accessibility of the probate courtrooms.
Yep.
Yeah, registrar's offices and probate courtrooms.
Again, the parentheses are because my wordsmithing skills have also decreased with the sun, and I can figure that out later. So the next question was about whether this report would include any recommendations about reallocation of jurisdiction. And that just brings a bunch of questions with it, which are all listed as sub-questions. But the major question is, do you, as part of this report, want to suggest moving any jurisdiction?
I think the answer is no, that we decided to allocate that to the 3-year review. But again, I jumped ahead of the queue. Justice Gorman, what are your thoughts on that?
No, I agree. I think we have to sort of stick with, if this passes, we need to stick with this plan for 3 years and see how well it works and then start tinkering.
Everybody okay with that? Seeing lots of nodding heads. Great. Thanks, everyone.
And then the question was also raised sort of in the deeper dive questions about transitioning. And in this case, I talk about the county probate court system, which is now to a state probate court system. And by that, I mean this model where there are state probate court judges. Obviously, the registry is state county based. And there were questions about whether there should be a specific timeline and schedule for implementation. I think Senator Carney said today that there might be some kind of transition committee and maybe leaving it to them. So I don't know if this question's already been answered.
Yeah, I don't think it's been answered. And I think it's a challenging question because we're dealing with elected judges currently and when their terms expire. Justice Gorman, do you want to share your thoughts?
I mean, we cannot remove anyone from office. And so the transition is going to have to occur as the judicial terms end or the judges step down. And some judges, for example, might want to actually be appointed to one of the regional slots and might step down for that reason, but we can't remove anybody from office.
Agreed. Leo, go ahead.
So it seems to me that those, once the legislature passes this initiative, then I think we have some flexibility, because I think 9 or a number of the probate court judges are going to end their terms in 2022.
Yeah, 7 in 22 and then 9 in 24.
So the ones that are ending their terms allow the possibility of having some judges appointed to fill the counties in which there will be no election. So you would have 7 of them, or you'd have 4 of them or 3 of them appointed to fill the work or to process the work in the empty counties, and have the other judges remain in place for another 2 years until their terms expired. And after that, you could appoint another, how many? 3, 5, whatever
Mhm.
makes 9.
Yeah. Yeah, this is a nice graphic that Janet is screen sharing, indicating which elected judges' terms expire when. I tried, I'd love to do puzzles, and I tried to figure, I was like, this is a great puzzle for a Sunday afternoon. And I think that it's very hard to do in a way that it's got to be done very carefully. And so my thought is that we suggest that the legislation that is offered set out a specific implementation schedule that accomplishes not removing any judge who has been elected prior to the end of term. And I don't think we need to propose that specific schedule in our final report, but that we need to make sure that it is proposed in the legislation. Janet, go ahead.
I'm glad Justice Gorman is here because she can say whether this sounds correct with the worry about removal from office. But if this legislation passes, my thought process is the constitutional amendment is triggered, so it's repealed. Then you just have statutory elected probate judges. Obviously, they've already been elected, they get to keep their term. But could the next round for all the people in 2022 is blue? Could the next round by statute for them be 2 years? So then everybody ends on the same day? Would that help her?
That's a really interesting idea.
It could.
Thank you.
It could.
What do we think of that idea, commission members?
The only problem I have is that we're delaying all of this until 2024. We don't have I'm looking at the budgets again. So 2024 comes round and we don't have budgets, the new legislature hasn't enacted budgets. I don't know who, I don't know. I'm very concerned about that delay and the implementation of this system. Now, there is a problem with having both elected and appointed judges as well. That's gonna create part of a problem also for 2 years. But I'm very, very wary of not having this thing funded when it comes up, and then being in a real pickle.
That is a good point. And Judge Mitchell, I know that you're anxious to say something. I think Judge Gorman's hand was up, and then you'll be right next. Justice Gorman, go ahead.
So Janet has made a proposal that is legal. I'm not sure it will work well Because what we would be doing is perpetuating the election of judges by one more election. And if that's not our goal, I don't think it should be part of this plan. If we look at who's expiring or which counties are expiring in 2022, Cumberland is a standalone region currently. Androscoggin and Franklin go at the same time. That's 2/3 of a standing region now. Hancock and Washington is one region. Penobscot is certainly the biggest part of its region. So it would be, again, it's going to be messy. It's going to be complex, but we could do it in 2 batches.
Judge Mitchell?
It was more of a question along those same lines. I wanted to superimpose the regions that we had with this map to see what went together. For example, Cumberland, I believe, was a district all unto itself. Is that correct?
Yes.
And so I was just looking at, well, of course, York is as well, but it was, I was just trying to superimpose those regions over this map to see if we could come up with something that would work.
Yeah, I have in my trying to figure it out, this is what I came up with, and I'll read it out loud and we can disseminate it to everybody. But so the seats that will be open at the end of 2022 would be District 2, which is Cumberland. 2 of the 3 seats in District 3, namely Androscoggin and Franklin, but not Oxford. In District 5, Penobscot, but not Piscataquis. In District 6, Knox, but not Lincoln, Sagadahoc, and Waldo. And 7, Hancock and Washington, both, which comprise of the entire District 7. The ones that will wait until 2024 are District 1, which is York alone. District 2, just part of it, namely Oxford.
That's 3.
Oh,
Sorry.
excuse me, District 3, thank you. District 4, Kennebec and Somerset. Part of District 5, Piscataquis. Part of District 6, namely Lincoln, Sagadahoc, and Waldo. And then District 8 in its entirety, Aroostook. And I can type that up and circulate it to people, but you can see it is complicated, and I don't know whether we want to noodle around ideas now or ask Sam and Janet if they might want to come up with some ideas that we could decide on at our final meeting in 2 weeks. There's a couple of different ways we can do it.
Madam Chair,
Judge Crockett, go ahead.
I just throw this out here, and I'm not trying to, I don't think we should go delve much deeper. But if members of this commission are part of this transition down the road, something they should keep in mind is that a lot of the existing probate judges will probably not continue as judges. So there can be buyouts, and given the cost of some of their existing salaries, it's not much. So if it's a matter of paying, Washington, I don't want to use a particular county, but some county, X amount of dollars for the judge to essentially step aside, it's not going to be, it would take some negotiation, but it could happen. You could end up with a lot resigning, depending on how it worked, because some of these are we have one judge who spends part of his winter in Florida and flies back for hearings and stuff. Obviously that's not going to work. We have some of them that are older that won't want a full-time schedule, and have stated that concern. I'm not assuming it. It's actually been stated. So you've got flexibility when the time comes. I just offer that as something to bear in mind.
Thank you very much. Go ahead, Judge Mitchell.
Just saying, rather than the buyout, you also have the opportunity to say, look, we're not going to appoint you for a 7-year term, but we need some on the ground experience. Would you be willing to negotiate with your other partner and accept a temporary judgeship? Should they be vetted out properly by the committee? Still have to be appointed by the governor. It's just a conversation one could have.
Okay. So, but as far as our decision today on this issue of the implementation timeframe, and I wholeheartedly agree with you, Representative Cardone, that we really want to implement it as soon as possible. Do we want to come up with a plan for implementation between now and our next meeting and kind of plug that chunk into our report. Does that seem like a good, because I feel that our creativity has set with the sun, along with our wordsmithing.
I'm going. Yeah, I think that's a good idea. The only thing I would say is that somewhere in here, we had said that you got to have one judge per region. So if I'm counting right, and my ability to count goes hand in hand with my wordsmithing, but if I'm counting right, we will have all or parts of 5 regions vacant in 2022. So we might have to start with actually 5 judges, even though like somebody, assuming that the judges in Saginaw, Lincoln, and Waldo all want to keep their seats until 2024, one judge might be covering only Knox County. But again, that's something to think about. But if we're going to stick by, you got to have a judge in a region. It looks to me like we're going to have at least 5.
Okay, so let me call on Judge Crockett, and then we can work on that timeline plan between now and 2 weeks from now. Go ahead, Judge Crockett.
Forgive me, that was a residual.
Okay. Thank you. Any other comments on the timeline issue before we move on? I am not seeing any. Thank you, everyone.
Okay.
All
so
right,
I
go
wrote
ahead,
it-
Janet.
I wrote it as the chairs will develop a plan. We're happy to help, but we can't propose it.
Okay, thank you.
And then,
On that topic, please, Representative Cardone and I will come up with a recommendation and present it at the next meeting.
okay, the only other question was one we already talked about, which was whether there should be a phased-in approach set out in this report, or whether that should be something really looked at in the 3-year review. And I believe you all agreed that the 3-year review really will look at that. But it sounds to me like by making the 3-year review look at that, you are saying affirmatively, so you want us to write in the report that you are affirmatively stating that the ultimate goal is, if this model is adopted, I understand not everybody on the commission agrees with the model, but if this model is adopted, the ultimate goal is full incorporation, and that the 3-year review looks at next steps maybe to do that. Is that correct?
Let's ask members of the commission. So Janet's question was, given that the 3-year review is going to look at additional opportunities for incorporating the probate court system into the judicial branch, that would be, it's not a recommendation at this time, but it is that there would be a statement in the report that that's the ultimate goal. And do we all feel comfortable with that? Judge Crockett, go ahead.
Yes, yeah, I think there has to be something. Any of these models have to come out with that and stay.
Thank you. Any additional agreements or, on the other hand, disagreements with including that statement? Okay. I think, looks like, from what I'm gathering, it looks like everybody's in agreement on that. Okay.
Well, those were the questions we had. That doesn't mean that somebody else didn't have other ones they wrote down as well.
Okay.
But that's the whole of our list.
Okay, so let's do this. Let's see if there's, I'll just ask members of the commission any more questions or points to make about Model A. And then Janet and Sam, do you also have questions about that need follow-up on Model B? So let me turn first to the members of the commission. Anything else on Model A before we shift to Model B? Glancing at everybody to make sure I've seen. Okay, I'm not seeing anything else on Model A. And then I know that you are working fast and furiously over there. Janet and Sam, let us know when you're ready with additional questions on Model B. And commission members, if you have questions, please note them down so that we can be asking those as well.
I'm gonna screen share again, but sort of type as I talk. So hopefully that works. It's like walking with chewing gum. Might not work. I did want to make sure that I understood Judge Crockett's proposal for Model B fully, because just like with Model A, as you can see, I can hear something and think that's what everybody said, but it may not actually be what everybody said, and I do not in any way want to mischaracterize your proposal, Judge Crockett. I don't want to get it wrong.
Well, let me make this easy for you. It's 4:38, almost 4:40. I withdraw any potential proposal. If the bulk of the committee wants to go with this Model A, I run with it, and we can just vote it up or down and go with it that way. I don't want to waste the committee's time, especially at 4:40 at the end of the meeting, and we either have to vote today or at the beginning of the meeting next time. So I withdraw anything. I certainly don't want it to be called the Crockett model. So there you go.
Sorry.
It's called Model B. And
You
if
know how these things go.
Yeah, but seriously and sincerely, if you would like us to incorporate a second proposal in, or you or any other member, I mean, you could say you don't want it in and maybe another commission member would want it in. If you or any other member of this commission would like a Model B, the Model B in the report, then we should gather the information we need to include it now. And so I'll open it up both to you, Judge Crockett, and to other members of the commission. Is there any member, or are there members who would like to move on with Janet and Sam's questions to fully incorporate Model B in the report? Okay, it seems like that we are kind of moving toward just including Model A in the report. Is everybody comfortable with that? Okay. Since we have been discussing both Model A and Model B and our ultimate goal throughout the day today, are commission members ready for a vote on Model A? Okay, Representative Cardone says that she is, which means that you get to make a motion. And then we'll do the motion in a second, and then we'll have discussion.
I move that this commission complete a report that recommends that the legislature adopt the changes to the probate court system as set forth in what we have termed Model A, to move forward with probate judges that are full-time judges appointed and paid for by the judiciary, along with the other provisions that we have discussed and put into Model A. Do you need me to be more specific than that?
I don't think so, because we are also actually going to vote to adopt the report that we'll consider at our next meeting. So I think that that's sufficiently specific. Thank you for the motion. Is there a second? Seconded by Leo Delicata. And now I'll open it up to discussion. Who would like to start the discussion of the motion? Okay. Is there any debate on the motion? Oh, Justice Gorman, thank you. Go ahead.
So I just want to say that I will support this, despite the fact that I have some lingering concerns about how this can work. I continue to be very concerned about what I referred to as turf wars between state and county government. I fear that this will exacerbate those as opposed to cooling those. But I'm convinced by something that both Mr. Delicata and Judge Mitchell said, which is we need to move forward. And this is a step forward. It's a bold move forward. And we have to try something. If it doesn't work, at that point, we'll have 8 or 9 or 10 more state judges, and we'll be in a better position to figure out whether that's enough and how we can better either incorporate or replicate the register system in the state court system. So that's my position.
Thank you. Judge Crockett?
I first of all, I applaud the work of this committee chairs. You've done an excellent job being collaborative, and I hope whatever input I've contributed has helped in some way. I like the idea. I think the end state is where we need to go. I don't want to create the problems that I think this hybrid model, I think you're actually going to create a worse system potentially than what we have, just because of the turf wars. I hope I'm wrong. If this passes, I sincerely hope I'm wrong. And if it passes, I will do everything I can to help implement and cooperate in the process. I don't think it's a good result, but I like the fact that you've put so much thought into it, and there's possibility of finally getting that integration to the judicial branch eventually. You've segued that. I'm going to oppose it, but again, I'll be the loyal opposition. If there's something I can do to help, by all means.
Thank you. Other comments or discussion? Go ahead, Judge Mitchell.
Thank you, Madam Chair. It pains me to be on a different side of the aisle from my colleague, Judge Crockett. I want to tell everyone here, I am not speaking on behalf of probate judges. As you can see, we're independent thinkers, and many people will support it and many people will not. I am in this position of supporting the motion because I believe the time has come. After 50 years of water dripping on a rock, it finally breaks it away a little bit. The other part that saddens me, if I may be personal, is that my husband, James Mitchell, was probably one of the best probate judges ever. He was elected, he wrote the manual on probate law, and he thought it was a darn good system. And I'm not sure how he'd feel about my voting this way today, but he did also teach me to be an independent thinker. So it's not perfect, but the perfect is, in my experience in the legislature, is always the enemy of the good. And I too didn't want to spend all this time without taking a bold step to try to deal with this lingering controversy over elected probate judges, which we don't feel comfortable with in our state. Many people do not. And the apparent, if not real, conflict of interest of that judge practicing before a colleague. So this bill does away with that. And it also protects something that I've come to cherish. And as I said, again, I'm spoiled because I have Kathy, who runs my court so well. And we have a relationship that is not just with a law clerk. And I hope that we can continue that in this new model. We chat over issues. We talk about what's been done before. She's been like a law clerk. And then she also pointed out something I want you all to be aware of. We have clerks who specialize in adult guardianships, minor guardianships, wills and estates, and they're not the same. So we use that expertise, and I'm hopeful that we can maintain that, as well as the customer service, because that's so important. And I also thank you for making sure that the fees for the things that are so important for justice and due process are going to be shared with the state. So I think it has a lot of good in it. It's a huge leap for me and for lots of folks sitting around the horseshoe. I do have a vested interest in it because I have lived it and breathed it for the past 5 years. But I think this commission has done a remarkable job, and I appreciate the input of Justice Gorman, because we're going to be working. She presented, by the way, to the Family Law Advisory Commission, what we were doing. And she's been so open-minded and so constructive, and I really appreciate that. So thank you for letting me speak. I will be supporting the motion, but I have a lot of emotion about it as well. Thank you.
Thank you very much. Leo Delicata, did you wish to speak as well?
Thank you. I will also be supporting this motion. I adopt everything that Judge Mitchell just said. And I will add that Judge Mitchell, your husband is still proud of you. I think this is a great accomplishment. It's a wonderful first step, and that's all this is, a first step. It needs to go to the legislature. We who are supporting this motion need to understand that and do what we can to educate the legislators that are going to be dealing with these issues and this piece of work, and impress upon them that we really are standing on the shoulders of many, many professionals who, and I've said this before, I'll say it for the last time, who have spent countless hours and energy in dealing with this Gordian knot of a problem for a very long time. And I think that what this commission has begun is the disentanglement of that knot. And I hope to see this implemented. And I will do whatever I can to make sure that it is. And I, again, on a personal note, I would like to thank everyone who is a member of this commission and everybody who participated with either written testimony or oral testimony for their interest and the amount of time and energy that you all have expended with this effort. Thank you.
Thank you. Commission members, would anyone else like to speak on to the motion? It's not seeing any additional hands up. Judge Crockett, is your hand residual? Yes. Okay, great. All right. All right. Well, with that, we will move to a vote on the motion. And just to remind members of the commission and those who are members of the public who are listening, everyone present today will have an opportunity to vote now. And then members of who have been appointed to the commission but who were unable to attend today will be able to register a vote by emailing the commission analysts, Janet Stocco and Sam Seneft, and also the chairs, Representative Cardona, myself, before 5 p.m. tomorrow. And so I think I have a sheet with everybody's name on it. I want to call the roll in a very efficient way. You know what, Janet, do you have a listing? Because of the members of the commission. Oh, actually, never mind. I just found mine. Okay. Oh, hang on, everyone. Thank you so much. So the pending motion is adoption of the report recommending Model A in order to incorporate the probate courts into the judicial branch. And I will call the roll. Senator Lisa Keim, absent. Representative Barbara Cardone.
Yes.
Representative
Yes.
Representative Aaron Sheehan.
Yes.
Representative David Hagan, absent. Judge Crockett.
Nay.
Thank you. Tudor Goldsmith,
Yes.
Kathy Register Ayers,
Yes.
Leo Delicata,
Yes.
Justice Gorman,
Yes.
Julie Howard,
Yes.
Judge Martin,
Yes.
Catherine Wiltuck,
Yes.
Judge Mitchell. Could you turn your mic on, please?
Yes.
Thank you. And Judge Avantagio is also absent, and then Ann Carney is a yes. And so the yays are 11 yeses, 1 no, and 3 absences. And so the motion carries. With that, I think that we have completed a tremendous amount of excellent work. And I did really want to thank everyone from the bottom of our hearts for all of the time, energy, effort, and wisdom you have imparted during the first 3 meetings. And we very much look forward to our meeting 2 weeks from tomorrow, which will be our final meeting. And I'm going to turn the microphone over to Sam and Janet for some logistical information. Is there anything that you would like to let us know about logistics for our final meeting?
Not at this time.
Okay, thank you. So in the interim, Sam and Janet will be working on the report, and we will circulate it in advance to commission members, correct?
I do not know. We have Thanksgiving coming up, so we will have to figure that all out.
Okay, we will be in touch with you regarding the procedures between now and our next meeting. Thank you very much, everyone. Have a nice evening.
Thank you all.
Do you want to move to adjourn?
Move to adjourn.
All right.
Have a happy Thanksgiving.
Happy Thanksgiving.